on 31/24, the teacher matter, my lord, who is working since 2006. And your lordship directed to bring instructions on the ground. May I pray that it may be taken up tomorrow? That this bench is
Tomorrow?
available. Your
How about-
lordship has heard the matter, only that instruction is awaited.
Who is the other counsel?
Other counsel, I'll
My
inform them.
sibling is out of station, your lordship.
Tomato, no,
Is
No.
18?
no, no.
Oh, sorry,
It's
sorry.
different. Standing Council Education is there, I'll inform him. madam.
Yes, you are there, education?
Yes,
Tomorrow you want?
No more matter. Then police present.
No.
All of it.
So why not on Monday?
Wonder whether this bench will be there or
Yeah,
not.
will be there.
May I please, your lord?
Yes, please.
My lord, I have filed a writ appeal last, on 30th of January. It may be kindly listed on Monday next.
Let be Wednesday, 7th.
My lord, Wednesday, I am going to Nagaland on Tuesday, lord. Tuesday.
May I please, your lordship? I'm back to mention item 18 and 19. In item 18, we are the petitioner. In item 19, we are the respondent.
Yes, what do you want?
After if matter may be taken up after we got any convenient date.
Lordship, let the matter be kept after 4 weeks. Lordship. Similar matters are pending before the Supreme Court.
Okay.
Let it be after 4 weeks.
You are appearing on behalf of,
SCCAL.
on
Sir.
request made on behalf of SCPL, not SGI. For the applicants. Please matter after 4 weeks.
Obliged.
I also like to mention item 20.
Yes. This also 4 weeks,
Yes, your lordship.
same order.
May I pray for listing of one review petition, my lord? That was against the writ appeal, my lord. Judgment of the writ appeal. The writ appeal was the judgment was delivered by the then Honorable Chief Justice and Mrs. Justice Susmita Khan, my lord. So, my lord, this review appeal review petition was filed on 8/9/2023, my lord, way back in the September, my lord. May a bench may be constituted and may be taken up next week on any day, Wednesday or Friday, my lord. Obliged, my lord. Wednesday, my lord.
Maybe Friday will be.
Friday. Obliged.
May it please your lordships, my lord, item number 25, my lord, hearing matter, my lord.
Hmm.
Mr. Goyal is supposed to argue this matter, my lord.
Hmm.
He has some difficulties, my lord. It will be listed after 3 weeks, my lord.
On request made on behalf of Mr. A. Goyal, then the counsel for the appellant, list after 3 weeks.
Obliged.
May it please your lordship. My lord, with the concern of the other side, lordship, I beg to mention for item number 29 to 43, lordship. My senior is having some serious matter in 2 different courts today, lordship. So let the matter be fixed on 18 or 19, lordship.
Lordship, in this matter may be taken up after 20, because my senior will be up.
Who's your senior?
DK Das, lordship.
Item?
29 to 43, lordship.
Okay, on request made on behalf of Mr. D.K. Das, Leonard, counsel for the response number 1. List the matter, when do you want?
20 to 21.
After 20.
Okay.
Okay. 27.
22.
Up to 43, is it?
Yes, sir.
Intelligence may be continued.
Interim order passes. Till the next.
Deeply obliged.
May please, your lordship.
Hmm.
With concern of the other side, my lord, I'll beg to mention item number 16 and 17 of the daily list. Appear on behalf of the petitioner. May be taken up after 2 weeks.
You are appearing on behalf of?
In both the matters, I appear on behalf of the petitioner, my lord.
Your good name?
R.B. Guhai.
On request made by R.B. Goen, Leonard counsel for the petition. List after
2 weeks, my lord.
2 weeks.
Yes,
May please your lordship, I beg to mention item number 7 and 8. The matter may be passable for the day. My senior is out of station.
Who's your senior?
MJ Kadir.
On request made on behalf of Mr. M.G. Kadir, Leonard counsel for the appellant. List after
On Monday, my lord, if possible.
Not Monday. Monday is full.
My lord, 7 to 12, we are also not there in Guwahati. We will go
The
to
19th.
19th, obviously.
May it please your lordship.
Mm.
Lordship, with the consent of the other side, I beg to mention item number 28 of the day.
20?
8.
Yes.
Lordship, in this case, we are led by senior counsel, Mr. K. N. Chaudhary. He's having some difficulty today, Lordship. Let the matter be adjourned.
2.
Lordship, let the matter come after 2 weeks.
On request made on behalf of Mr. K. N. Chaudhary, senior counsel for the petitioner, list after 2 weeks.
Much obliged.
May it please your lordship, I beg to mention for listing of the matter. This matter it is relating to selection and appointment. On the last occasion, it was listed on July 2023. And an Honorable High Court has passed an order for listing of the matter after 2 weeks, but till today it was not listed.
Okay.
Matter may be listed up
23rd.
23rd. Much obliged.
May I please, Your
Hmm.
Lordship? My lord, I beg to mention item number 9 to 14, my lord.
Hmm.
This is my adjournment slip has been circulated.
Hmm.
I am appearing on behalf of Mr. BP Bora, my lord. Pass over for 4 weeks, my lord.
Okay, on request made on behalf of Mr. B.B. Bora, learned counsel. Appearing for the response number 1.
Yes.
In writ April 360 of 2014. List after
4 weeks, my lord.
4 weeks.
Highly blessed.
Item 1 for motion.
May I please, Your Lordship?
Hmm.
Lordship, as per order of this honorable court, Lordship, the petitioner has paid the 25% of the outstanding dues, Lordship.
Hmm?
Petitioner has paid 25% of the outstanding dues, Lordship. I
Hmm.
have also submitted additional affidavit, Lordship. I think, Lordship, it is on record, Lordship. Last date, this honorable court also give direction to place on record, Lordship. 25% we have received, Your Lordship.
Yes.
Yes, you received 25% received, Lordship.
Yes.
They may be asked to pay another 25%, Lordship. Remaining, Lordship. Another 25%, Lordship. Lordship may give direction to the respondent to regularize the petitioner's account, Lordship, through monthly installment, Lordship. For that, they have to file a OTS before the bank loan.
You have to file your ODA.
Okay. Lordship, I will file a representation regarding this, Lordship, for one-time settlement. I mean, earlier I have filed, Lordship, but they did not accept it, Lordship. After this order of this honorable court,
So
Lordship,
you want to have this matter disposed?
Lordship may be disposed directing the responding authorities to regularize the petitioner's account through monthly installment, Lordship.
Let the-
the proposal, bank will consider, Lord.
Let the bank consider.
Lordship, yes, Lord.
Yeah, Mr.
NH Laskar, Lordship.
Heard Mr. N.H. Laskar, learned counsel for the petitioner. Also heard
A
Mr.
Dhanuka, Lordship.
A.
Dhanuka.
Dhanukar, learned standing counsel, Punjab National Bank.
I'm not the standing counsel, Lordship.
Learned counsel for the Punjab National Bank. For all the respondents. Stop. The petitioner took a term loan of rupees 4,80,000, isn't it?
Lordship, kindly some page, Lordship, 20, Lordship. 4,24,728, Lordship.
Page?
20, Lordship.
No.
Oh, yes, Lordship.
Page 17, Lordship.
17, Lordship.
No, 17 is different thing. A term loan of rupees 4,80,000 only. Bearing account number 1866
Oh, yes.
3 000 2813. And another term loan of rupees 50,000
Yes, Lord.
only. Bearing account number 1866 3 000 2073, totaling to an amount of rupees 5,30,000. On stop. The petitioner was paying the interest amount till the onset of COVID-19. Stop. However, not however, thereafter, as there were some problems with his business, he defaulted in paying the interest loan. And accordingly, the respondent bank issued, where's the sale notice?
Page 19, Lordship.
Issued sell notice. Dated issued notice of sale of immovable properties on 28/11/2023 for an amount of rupees 4,24,728.31 only on the basis of, within bracket, inverted commas, you put as is where is, comma, again within inverted comma, as is what is, and within inverted comma, whatever there is. On no, 1 minute. Don't say like that, huh? So that's an amount of 4,724,728. Stop. Drafter by another notice for sale of immovable properties dated 30/11/2023. Another notice was issued, isn't it?
Yes, Lordship. Two notices was issued. One is grantor and one is the petitioner, Lordship.
Oh, no,
Abu Talib was the borrower, Lordship,
Borrower,
and Rina Begum was the grantor.
grantor.
1 minute.
28/11 one and 30/11 another, Lordship. Same sale of immovable property.
30/11 is to whom?
30/11
Borrower, Lordship.
borrower, Abu Talib, petitioner, Lordship.
Another notice of sale for immovable properties dated 30/11/2023. Only on the basis of as is where is, comma, as is what is. And whatever it is. Stop. Para. When this matter was heard on 21/12/2020, the learned counsel for the petitioner submitted that the petitioner is willing to pay 25% of the outstanding due on or before 2nd of January 2024. Stop. Accordingly, this court permitted the petitioner, directed the petitioner to pay 25% of the outstanding due to the respondent bank on or before 2nd of January 2024. And both the sale notices dated 28/11/2023 and 30/11/2023 were suspended. Stop. Para. Today, when the matter is taken up, the petitioner has filed, when the petitioner cancel it, para. Petitioner has filed an additional affidavit indicating that the petitioner has paid an amount of rupees 95,500 in account number 1866 300002813 on 30/12/2023 and an amount of rupees 14,500 in account number 1866 300002073. Stop. Para. Learned counsel for the petitioner submits that the petitioner would be filing a representation for a one-time settlement before the respondent for consideration of bringing the of for consideration of the bank. Stop. Para. In view of the above, comma, this writ petition is disposed of, directing the petitioner to make an application for one-time settlement before the Punjab National Bank. Which area is this?
This one number 3, Lordship.
Before the response number 3 of the Punjab National Bank.
It was the- Authorized circle officer, Lordship. Authorized officer of
Before
Punjab
the
National-
response number 3, comma, oblique chief manager, comma, authorized officer of Punjab National Bank, comma, Circle Sastra Sandar,
No,
Nagaon. Within the period of 1 week,
10 days, Lordship.
within the period of 10 days from today. Thereafter, comma, the respondent bank shall consider the application made by the petitioner for one-time settlement and pass appropriate orders.
Lordship, may one-time settlement or monthly through monthly installment, Lordship. For regular is carried.
That will come automatically
Yes, Lordship.
with the above directions, observations and directions, which petition is disposed of.
And
When can you have the,
Within 15 days after
within a period of 15 days, huh?
after the receipt of the
From the date of receipt of the application.
I'll limit.
Item 226 for admission.
May I please? In the order dated my lord 22/9/2023 passed in the writ appeal, my lord. Yes, 22/9/2023 passed by this honorable court, my lord, where it is submitted by the appellants that connected WPC are premature. And this honorable court therefore tagged the matter, my lord. In respect of WPC number 5770/2022, my lord, my learned friend has instituted the same manner. And in the said writ petition, there was an interim order and subsequently it is vacated. Vacated by this honorable court, my lord. So, my lord, my humble submission, subject to my learned friend's acceptance, my lord, all the cases, my lord, should be disposed of with a direction to the Director Elementary Education, my lord, to consider the promotion aspect of the petitioners as well as the appellants as well as the respondents, my lord, whoever, and a fresh manner, my lord. If my learned friend agrees.
Fresh steps may be taken because our plea is that, my lordship,
Now, what is this 1 minute?
This is with regard to promotion to the post of upper primary, headmaster of the upper primary schools, my lord, in respect of Hailakandi district.
already selection list has been lapsed, my lordship. 1 year has been already over.
Due to the pendency of this writ petitions, my lord, instituted by him, it cannot be lapsed, my lord. In the pendency, he has instituted the
Our main grievance in the writ petition was that, my lordship, in the year 2021, a gradation list was prepared. And on the basis of that gradation list, a selection list was prepared. Our name was included in that selection list. Subsequently, the selection list was forwarded for approval
of the government.
Department.
During pendency of the selection list, my lordship, another graduation list was prepared in the year 2020. In that graduation list, our name is not there. So it is very much arbitrary that on the previous year, our name is there. On the subsequent year, how can our name be deleted from the graduation list? And even our name was not recommended for promotion, my lordship. So we filed the writ petition, my lord. During pendency of the writ petition, my lordship, they have prepared another graduation list. In that graduation list, also they deleted our name, my lord.
Who appears for the department?
Education elementary, madam.
Hmm.
I like one.
Then only we can send it back.
Oh.
Of course, other writ petition are pending. One
Hmm.
writ petition, one. Nothing matter.
We have to hear this writ appeal. We have to hear the writ appeal first. After that,
Yes.
only we can take a decision.
Yes, my lord.
Writ appeal.
Elementary education, you are appealing?
Mr. Amazundar will add.
Where is he?
He is in 430, my lord.
Court?
430.
Writ petitions, my lord, but in that event, may be segregated, my lord, because this, these are
It
not.
was
connected.
on your prayer that it was.
It was at the prayer of my learned friend, it is tagged, my lord.
Well, all are similar methods, my
All are
lordship.
similar.
Similar.
So let Majumdar come. We'll wait for.
After some time, my lord.
Item 44 from supplementary list.
May please your lordship. Well, this is an appeal by the private respondent in the writ petition. The matter relates to settlement of a market, Vadodara market. It was settled with me. The writ petitioner filed the writ petition claiming to invoke clause 10 of the NIT, which says that he was the highest bidder and he should be given 3 days time to replenish the documents because he had not filed the document. The learned single judge, my lord, allowed the writ petition, holding that he may be allowed to replenish those documents by invoking clause 10 of the NIT. That and settlement was set aside, and to direction was given to the authority concerned to redo the exercise by giving him chance to replenish those documents. Now, clause 10 here, your lordship, please to see at page 45, 46. That was a clause which has been held to be illegal by a coordinate bench of this court. 45, it is at 46. 46 clause 10 down below. The tenderer of all Bajar Ghat beam asphalt pound offering highest bid price would be considered for settlement. If the tenderer offering highest price does not enclose the relevant papers and documents except court fee and earnest money, that is, he must give the court fee and the earnest money, and the relevant other the documents are not required to be given to him by him. He will be given a period of 3 days for submission of such papers and documents, and if he fails to submit the papers and documents within the specified period of 3 days, his or her tender will be cancelled, and his or her earnest money will remain forfeited, and the next higher bidder shall be considered for settlement with the same terms and conditions. this was a case, this clause was the subject matter of a decision of this honorable court. It is in WPC 6902/2021, Abdul Samad versus State of Assam. I am giving a copy to your lordship, which said that this clause is a standalone provision. It is incompatible with the other clauses of the NIT, and therefore no benefit can be given to him. And this 6902/2021, I will take your lordship to paragraph 3, 6.1, paragraph 3 first. What was the case of the petitioner? Para 3. Agreed by the order of settlement issued in favor of the respondent number 8, the petitioner approached this court by the writ petition, challenging the same on the ground, inter alia, that the market had been settled in favor of respondent number 8, despite the petitioner quoting the higher bid than the respondent number 8 in settling the market. The respondent Jila Parishad did not adhere to the condition incorporated in clause 10 of the tender notice. He wanted to invoke clause 10 of the tender notice. Now, your lordship please to find paragraph 6.1. What was his case? 6.1 at page 6. By referring to clause 10 of the tender notice, he has contended that the petitioner, being the highest bidder, was entitled to given an opportunity to submit the requisite documents in case the tendering authority had found the bid of the petitioner deficient in some document within a period of 3 days. As the clause 10 incorporated in the provision for forfeiture of earnest money in the event of default to submit the documents to be asked for within a period of 3 days, the same was required to be followed by the tendering authority. But in the case in hand, the tendering authority did not adhere to the said clause. It is his contention that the tendering authority has to abide by the terms and conditions of the tender notice and could not have been deviated from the same. That was his case. Now it was held paragraph 20, 14, 16, 1. Paragraph 20 at page 15 minutes. Down below, in the light of the discussions made above, it is clearly emerged that clause 10 is a standalone provision and the procedure prescribed therein is incompatible to the terms and conditions incorporated in the tender notice. Clause 17 of the tender notice has inter alia set forth that in the event a bidder does not meet the terms and conditions incorporated in clause 11 to clause 16, the bid would entail rejection. Clause 11 to clause 16 of the tender notice requires the bidder to submit the paper number of documents described therein to accompany the bid. If the procedure indicated in clause 10 is required to be followed, as has been contended in behalf of the petitioner, one could also contend that the same would be aberrant to the competitive bidding process, as there would not be any fairness, transparency, definitiveness, and rationality. Then paragraph 21, your lordship, down below. From the above, if it is certain, that is, if clause 10 of the tender notice is made applicable, then the same would be for the benefit of the bidders whose bid was invalid at the time of their submission, and the same would be to the prejudice of those bidders whose bid was compliant to the terms and conditions of the tender notice. at the time of their submission. The issue of acceptance or rejection of a bid of the bidder is to be examined not only from the point of view of both of the tendering authority and such a bidder, but also from the point of view of all other participant bidders. The said situation is clearly opposed to the principle of equality enshrined in clause Article 14 of the Constitution of India. The same would be clearly discriminatory in as much as it would result in an anomalous situation where unequal should be treated equally, giving them unjust benefit. Then paragraph 21. I am reading to paragraph 20. Then 22, ultimately. Page 18, paragraph 24, my lord. Having regard to the entire facts and circumstances obtaining in the case in hand, when the aspect of the higher bid value offered by the petitioner, which bid was non-compliant with the terms and conditions of the tender notice at the time of submission of the bid, is considered, qua the decision of the General Standing Committee of the Jila Parishad. General Standing Committee decided the matter to accept the bid of the respondent number 8, whose bid was compliant to the terms and conditions of the tender notice at the time of submission. This court is of the considered view that it is the decision of the General Standing Committee of the Jila Parishad leading to the impugned order of settlement, which is to be respected for keeping the competitive bidding process initiated by the tender notice fair, and transparent, and non-discriminatory one in public interest, and as the said decision is found in conformity with the principles of equality and drafted under Article 14 of the Constitution of India. Now, last paragraph, last line. As a consequence, this court is the considered view that the writ petition seeking interference in the impugned order of settlement made in favor of the respondent number 8 and for settling the market in favor of the petitioner by invoking clause 10 actually, merit lacks merit and the same is liable to be dismissed. The clause 10 was held to be a standalone provision and no benefit was given, but it was in subsequent case, my lord, clause 10 was subject matter of a challenge within this honorable court, and there is a stay order of clause 10. In our case, my lord, we have given at page memo of appeal at page 64 to 74. (64 to 74) at page 68, my lord. Page 68. 72. At page 68, paragraph 11, consider the rival submissions made in the matter. It is observed that in the proceeding of 6902/2021 that I have thrown to your lordship, the validity of clause 10 of the NIT was not under challenge because as per the facts of the said case, the bid of the petitioner therein was not compliant, and therefore the petitioner therein sought to invoke clause 10 of the NIT so as to impress upon the court that he should be given an opportunity to furnish those additional documents to make his deed valid. Under these circumstances, this court, by an elaborate discussion, has held that clause 10 was discriminatory, and therefore the interpretation sought to be given on clause 10 of the NIT by the petitioner in 6/9/2021 was not accepted by this court, refusing to give liberty to the petitioner under clause 10 of the NIT to produce the document. Accordingly, the writ petition was found lacking merit and the same was dismissed. Then paragraph 70, my lord. Page 70, paragraph 13. From the above, this court finds support on the point that the observations of the coordinate bench of this court in WPC 6902/2021 that your lordship has just read cannot be said to be an expression or opinion which was not necessary to support the decision of this court. The reason is simple. Because in the proceeding of the 6902/2021, the petitioner therein had invoked clause 10 of the NIT to urge that he should be got an opportunity to supplement his tender, which is the proposition not accepted by this court. The court could not have taken an appropriate decision without applying a judicial mind on the scope and ambit of clause 10 of the NIT. It was argued that this was an observation on the observation. In the other case that your lordship has read, 6902/2021, the court has said in this case, namely in this case, where the clause 10 was under challenge, it was subsequently stayed. Present NIT. Page 73, paragraph 18. In view of the discussions above, page 73, paragraph 18. In view of the discussions above, as an interim measure until the next returnable date, the executive officer Bottleba Ancharik Panchayat and the president Bottleba Ancharik Panchayat, the same Panchayat manner, here also. In our case, are restrained from taking recourse to clause 10 of the NIT dated so and so, while accepting this bid, informed and shall inform the bidders that clause 10 of the NIT will not be applied till the next date of listing. Now, that was hung on the notice board at page 135. It was by the bottom of Ancharik Panchayat. It is hereby notified that all the tenderers who have submitted the tenders for settlement of Bajar Hat, so and so, that clause 10 of the NIT issued by the bottom of Ancharik Panchayat will not be applicable as per order dated so and so, passed by the Honorable Guwahati High Court in WBC number 3325/2023. Aforesaid clause will not be applicable until further order of the Honorable High Court. Now, your Lordship will be pleased to see the impugned order, which is the page 140, 140, it starts from 139. Your Lordship can matter to 140, 142. Para 6. it is submitted on behalf of the petitioners that if the documents offered by the respective parties are strictly examined, it would be revealed from the comparative statement that both the private respondent and the petitioner, Mohammed Mukhtar Hussain, did not fulfill the requirement of submitting documents. However, it is submitted that when the tender condition itself provided for granting 3 days period to submit the document, it was obligatory on the part of the respondent authorities to make an assessment of the price bid for those tenderers who otherwise have fulfilled the requirements of the tender condition. It is further submitted that the matters of distribution of state largesses, which are meant for fetching revenue, the price offered by a party is the relevant factor which is not liable to be ignored, and the difference in the price is offered is over 18 lakhs. Now, paragraph 10, next page, 143. Upon hearing the rival contention and perusal of the materials on record, the comparative statements of the responding bidders would disclose that though certain documents appear not to have been submitted by the petitioner with the bid, there is also deficiency on the part of the private respondent, that is myself, who has not offered the who has been offered the settlement. The petitioner has given an explanation that clause 10 of the tender conditions would not permit rejection of his bid per se when all other documents have been submitted by the petitioner and in respect of only those documents which are covered by the aforesaid clause have not been submitted. It is submitted that the petitioner was not aware of the fact that the authorities would not take the relevant clause 10 into consideration because of the court's order. Your Lordship has seen the notice at page 135. Be that as it may, the court has noticed that deficiency in documents there are both in the bids of the petitioner, Mukhtar Hussain, as well as the private respondent. Court found some documents was lacking in respect of me also, while also to show that these documents are not essential documents. Upon the aforesaid fact, paragraph 13 then, upon the aforesaid facts and circumstances, the court is of the opinion that the interest of justice would be served by directing the respondent authority to redo the exercise of settlement by giving the petitioners and the private respondent to make good any deficiency in their documents within a period of 5 days from the date when the authorities would notify. Consequently, paragraph 14, the implement of settlement so is set aside and a fresh settlement is offered to the valid highest bidder in accordance with law. This is not valid highest bidder. Now, here, your Lordship please to see paragraph 9 at page 43. Paragraph 9 at page 43 in the judgment.
Paragraph 9 at page 43.
143. 140. I'm sorry. The court says, the Learned Single just says that there was lacking some documents in respect of me also. But so Learned Counsel for the private respondent has however submitted the bid of his client was valid bid as there was no deficiency in submission of the relevant document. He further submits that for documents wherein there is a comment of non-submission are not relevant documents, and therefore no fault can be attributed with the impugned decision not to settle the market in question. The court has not gone into that aspect of the matter. But what was the case of the petitioner at paragraph 5 and 6 of the writ petition, which I have enclosed at page 26? At page 26.
26.
26 of the memo. What is the case of the petition, writ petitioner? he had not, well, I can tell you, Lordship, that he had not given the documents with regard to his guarantor or the land document that was required to be given as security. Thus, the petitioner begs to state that while he was trying to obtain all the necessary documents which are required to be submitted with the tender, he has come across with the clause 10 of the tender notice, wherein it was clearly stated that the bid offered by the highest bidder will be accepted even if the said highest bidder had not submitted necessary documents except court fee and earnest money. And if it is found that the highest bidder had failed to submit the necessary document along with the tender, then the highest bidder will be given 3 days' time to furnish the necessary document. Paragraph 6. The petitioner begs to state that after knowing about the said provision, and since the last date was fast approaching, as such, the petitioner had submitted his bid without enclosing the document, like debt clearance certificate of the guarantor from the Jila Parishad, Ancharik Panchayat, and Gaon Panchayat, recent Jamabandi of the land given towards security of the bid price, land valuation certificate, etc. Under the belief that the petitioner would submit the same once he is called to submit the said by following the provisions contained in clause 10 of this tender notice dated 12th. Now this clause 10 he wanted to invoke. If now your Lordship goes to the comparative statement as page 58, that's page 58. Serial number 3 is the writ petitioner and 4 is the myself. Your Lordship, please to see in column number 7 and column number 8, column number 7, fixed deposit number so and so 1 lakh and above. If it is the case of if it bill value is about more than 1 lakh, then it is to be settled by the Jila Parishad. And if it is less than 1 lakh, it is to be settled by the Ancharik Panchayat. So, therefore, he had given, Mukhtar Hussain had given also this certificate, and I have also given the certificate. But the next clause is not required because it is below. No, it is below, clause 8. Below 1 lakh. It was above 1 lakh, sorry. It was not below 1 lakh. Therefore, clause 8 will be applicable if it is below 1 lakh. Therefore, it is not applicable in my case also. Then your Lordship please to see 9, number 9, serial number 9 in the 9 column, caste certificate. No, both. Caste certificate is not required because he does not belong to scheduled caste and all that. He is general caste. Caste certificate is required only in case of SC/ST. I'll show it, madam. Then your Lordship please to see 13. Revenue. Debt clearance certificate I have given. Jila Parishad, Ancharik Panchayat, Gaon Panchayat, I have given. But revenue certificate is not required under the clause. It was not an essential document as such. Then your Lordship is to say 17, the same thing. Debt clearance certificate of the guarantor. The earlier one was debt clearance certificate of the tenderer himself. Now debt clearance certificate of the guarantor. if one gives a guarantee, if one gives a security as a guarantor, then the guarantor's document would be required. The Mukhtar Hussain, the petitioner, he did not submit any documents of the guarantor. Your Lordship. In paragraph 6 already at page 26, he is saying so, that he has not submitted those documents. And that's why his tender was non-compliant. Then your Lordship please to hear bank guarantee at page Quran number 22. 23, 22, clause number 22, serial number 22. Bank guarantee. No, I am not required to give a bank guarantee because bank guarantee is applicable in a case where no guarantor is there for land settlement. This is referring to page 48, clause 14. Clause page 48 of the memo of it. How can your Lordship first read first? The tenderer and the guarantor should obtain tax clearance certificate and non-defaulter certificate from the concerned Jila Parishad, Anchalik Panchayat and Gan Panchayat, and I close with the tender. Tax clearance certificate, non-defaulter certificate from the concerned Jila Parishad, Anchalik Panchayat and Gan Panchayat. I have given it. Then the clause 14. The tenderer and the guarantor should mortgage land against the value of the tender. They should obtain Jamabandi and Khaw, non-income certificate of the land mortgage for the current year from the concerned Deputy Commissioner, Civil Officer, and enclose the tender. The guarantor shall also put his signature in the tender paper. Then, papers and documents of bank guarantee may also be filed with the tender instead of documents of landed property. Therefore, I have not given any bank guarantee because I have given the guarantor himself because he has kept his land as security. Therefore, the question of bank guarantee did not arise. Therefore, I have not given bank guarantee. But the court, Learned Single Judge, has gone into the comparative statement in such a way that if there is in some clauses there is no. But my submission was, the submission of the council was that it was not essential document. But the court has not gone into those matters. And in that respect, I may submit before your Lordship. The authority has considered the matter and settled the matter with me, settled the market with me. And in your Lordship, please to see, Mukhtar Hussain, the writ petitioner, he was not the highest tenderer. Highest tenderer was some Ismail Hussain. He was higher than me, of course. But he was not the highest tenderer. Highest one was Ismail Hussain. Though Ismail Hussain has not come before your Lordship. He cannot be said to be the highest tenderer. The clause 10 is otherwise also clause 10. Your Lordship, please to see at page 46 down below. 46. The tenderer offering the highest bid price. Highest bid price is considered to be Ismail Hussain. He has given the highest bid. He is not before the court. Had it been before the court, that it would have been different, of course. But Mukhtar Hussain, of course, he is higher than me. But he is not the highest tenderer. Highest means, my lord, very highest, and be highest among the tenderers. He may be higher than me, but he is not the highest. Otherwise also, clause 10 was stayed at the relevant point of time and the petition was pending.
Is it? Yes.
Therefore, my habit that the largest single judge Your Lordship, please to see page 59. The second appeal is against the Raisuddin. It is serial number Kimal? 5. It will be serial number 5. He had also filed a writ petition stating that he is the very highest bidder, but he is down below. But Your Lordship, please to see, there is no yes, other bidders, Your Lordship will see, there is non-compliance. The authorities have considered who is compliant with it and found that my tender was compliant in accordance with the terms and conditions of the tender and settled the market with me. Therefore, unless the same is held to be very arbitrary, then the judicial review is not permitted. Your Lordships are loath to interfere in those matters. When the authorities have considered the matter and have seen who has filed which document and whether the documents are in order or not, and they have considered it. And therefore, my humble submission before the Lordship is that when it was shown before the Honorable Single Judge, Your Lordship is to see the impugned order. No, impugned order. No, court দেখাইছে
Stay order is
Court
still subsisting. Is it? Stay order is subsisting. Justice Kulisura state the clause.
court orderটা হচ্ছে ইন্টারভিউটা দেখাইছে এখানে এখানে যে দেখাইছিলাম কোথায় আছে এখানে জাজমেন্টে কোথায় আছে
Have you placed all these judgments before the Leonard Single?
Yes, yes, yes. That is a. I am finding it. Darada. That. Court order. Paragraph, I have shown your Lordship that paragraph 10 at page 143, last line at page 144. He was not aware of the fact that the authorities would not take the relevant clause 10 into consideration because of some court order. In fact, my lord, what has happened, there is not a single judge. If your lordship looks to the interim order at page 6478, page 64, they have enclosed the writ petition in the order in the writ petition. And the Lord single judge, while granting an interim order, has discussed everything. Contrary judgments, this judgment at page 68. At page 71, my lord, of the memo of appeal, paragraph 16, I may read it. On examining the pros and cons of the permitting a tenderer to supplement the documents which are not accompanying the tender, the court finds that there could be a hypothetical situation where for specific intention, a bidder may not elect to disclose all the documents which he has. In the tender process, the tender's bids are opened in the presence of the bidder. Therefore, when a document is submitted with the bid, it will be open to the other bidders to question the correctness of the validity of the documents produced. However, if by applying clause 10, a document which has never been brought on record, along with the original tender, is accepted by the tendering authority, other bidders would lose an opportunity to raise an objection against the document. Such an acceptance of a document which did not form part of the bidding process would be an ex parte acceptance in the absence of other competing bidders. The situation, in the opinion of the court, is hid by Article 14 of the Constitution, as an equal opportunity has not been granted to all the bidders to examine the validity of the document. It is too well settled that bidding process must be done in a transparent manner, and therefore, everybody who is present in opening of the bid should also be made aware of the nature of the documents which are accompanying in the bid. If such an opportunity is lost, it cannot be said that the principles of constraint in Article 14 of the Constitution is not violated. Therefore, the court is inclined to follow the earlier judgment of this court, 1705-2022, passed in WPC 6902-2021, that your lordship has read as having more persuasive value than the subsequent judgment to 2311-2022, passed by a coordinate bench in WPC number so and so. As in the subsequent judgment, the previous order of this court was not considered or distinguished by applying judicial mind. In taking the aforesaid view, the courts find support from a constitution bench decision of the Supreme Court, so and so, where the Supreme Court in India had observed the disagreement with the earlier judgment of coordinate bench was impermissible. Hence, being bound by the ratio laid down by the constitution bench of the Supreme Court, this court would be inclined to accept the decision passed in 6902-2021. Therefore, the clause 10 was stayed, and a notice was issued by the Antarik Panchayat at page 135. That was brought to the notice of the court also, because at page 146, at page 144, last line, top, he was not aware of the fact that the authorities would not take the relevant clause into consideration because of some court order. The learned single judge has left his matter at that. And he has found fault with me also. But if I have submitted that the documents are not relevant documents. But on the contrary, he has not given the document required under clause 11 to 16. And clause 17 says, I can take your lordship to, and again, to NIT at page 45, 46, page 48. Page 48, clause 17, down below, part 1. The tender will be cancelled if the conditions of paragraphs 1 to 16 of part 1 and part 2 are not fulfilled. 11 to 16. 17 to 40. No, you can, what am I talking? Therefore, my submission before Lordship would be that the order passed for settlement, for cancelling my settlement and redoing the exercise by invoking clause 10 is illegal. Therefore, it should be set aside. Now the market is, after the judgment, the market is being run by the authority concerned. None of the parties are there after setting it. I can tell you, although I have filed a stay application separately.
There is a caveat.
You were not the highest bidder, isn't it? The petitioner was the highest bidder, above you.
Above me, but he was not there.
He was also not the highest bidder. There was another person who was the highest bidder.
Another 2%.
Another 2%. How were you selected?
Their documents were, their tender was non-compliant with the, in accordance with the tender notice, NIT.
All the three.
All the tender.
So clause 10 was not invoked.
No, clause 10 was not invoked.
In view of the stay order.
Yes. Clause 10 was not invoked in any case. None of the tenderers.
That interim order was annexed with the.
Yes.
That order is not, as on today, that order is non-ex, my lord. That is not been placed before your lordship. My learned friend, my lord, probably not, my lord. The time is not been properly instructed, my lord, because that order is already withdrawn, my lord. That is non-ex, my lord. And it means that, which is, my lord, my learned friend pointed out, I know senior friend pointed out, that is already been withdrawn, my lord.
And petition.
His petition has been subsequently withdrawn.
Withdrawn, my lord, that the interim order vacated, my lord. That was really, my lord, for a very first instance, that has to be pointed out. That was not been pointed out. Probably my learned friend was not being informed by his junior. He was very much present, my lord. I'll place, my lord, everything before your lordship. Your lordship, kindly hear me, my lord. Order which was referred, that was withdrawn. Regarding all, then I'll make my submission, my lord.
Cases of the order.
This interim order, that is page
68.
64.
was after relying the 56902, isn't it?
Yes, 6902. 6902 remained. 6902 remained.
The judgment still.
Yes, yes.
There is, my lord, conflict. There are two judgments. Your lordship, kindly, my lord, they have not read, my lord. Your lordship, kindly see that's the order, my lord. Page 68, 7, my lord. That will be
60.
page 67, my lord. That order, that the which was, my lord, pointed my lord, senior friend, my lord. They have not read, my lord, para 8. My lord, everything will be clear in para 8. Regarding clause 10, there is a two judgment of this honorable court. By one is Honorable Manish Chaudhary. That is, my lord, that clause 10 is bad. And Honorable Justice Sanjay Mehdi, that Justice Sanjay Mehdi's, my lord, order was that, my judgment is that, my lord, that clause 10 is held to be good enough. That, my lord, in para 8, it is clearly mentioned, my lord. I'll read the, my lord, para 8, my lord. Page 67, has your lordship got it?
Yeah.
By referring to the decision of the court dated 17/5/2022 by a coordinate bench, this court in WPC 6902/21 submitted that similar clause 10 was examined in the said clause, and it was held that the clause 10 was a stand-alone provision and procedure prescribed there. It is held to be incompatible with the other terms and conditions, and has also be held that said clause opposed to municipal equality, Article 14 of the Constitution of India, as a discriminatory, and it was held that the said clause was held not in entitled to petition hearing. The instead of the tender should be accepted merely because of the given tender in the highest and lowest, depending upon the nature of the bidding of the cases. It is fairly submitted that another coordinate bench judgments this court, while deciding WPC 4377 of 2022 by judgment and order dated so that the cognizance of the decision of this court, cognizance of this court that 17/5/2020 WPC 6902/20 upheld the validity of the clause 10 of the said NIT, which prima facie material to the clause 10 is present NIT. Now that is very important, my lord. Your lordship, kindly see, there is a one judgment. The earlier judgment is, my lord, this bad, clause 10 is bad, and my lord, subsequent judgment is clause 10 is, my lord, clause 10 is good. So that is the law point, my lord. One coordinate bench says it is good, one coordinate bench bad. Then, my lord, this impugn order, which was pointed by my lord, friend, my lord, that was, my lord, operating, my lord. That was operating. Because considering these two judgments, the judgment was passed. But now that judgment has already been withdrawn now. That writ petition has been done. As a result, interim order is no more, my lord. So now these two judgments is meant to stand, my lord. One is by the Honorable Justice Chaudhary and one is Justice Mehdi. In the impugn, my lord, settlement order, which was salient before this honorable court by the writ petitioner, in the very clearly mentioned that your settlement is subject to result of this writ petition, which has been withdrawn. That is very, your lordship, kindly see page 56, my lord. Page 56. Page 56. Has your lordship got it, my lord?
Yeah.
Page 56. Very last line. There is a settlement order, my lord,
Sure.
to Anwar Hussain. To Anwar Hussain. Anwar is the, my lord, the appellant here, my lord. Sorry, Amran Hussain. last line. However, the settlement shall be depending upon the final order of this honorable court, High Court, case number so and so, so and so, so and so. So that 325 of 2023, and that is the withdrawal order of the 323, my lord. Now, my lord, dear lordship, kindly, my lord, that is, my lord, regarding my lord, law point, my lord, regarding factual acts of the matter, my lord, I am submitting before your lordship. The entire record was produced before the learned single judge, my lord, before the learned single judge. The learned single judge, my lord, pointed out that there is a defect in both the, my lord, as well as petitioner, as well as respondent, my lord, in the tender, my lord. That's why, my lord, that was sent back to the authority by invoking clause 10 to give them the opportunity. Because record was produced, my lord. And the record, my lord, was clearly found that, my lord, that there is a deficiency of the NIT condition in both the parties, my lord. That is a clear finding, my lord, after perusal of the record, my lord. Now, my lord, one of the, my lord, very important point I am submitting before your lordship. In clause 14 of the NIT, clause 14 of the NIT, my lord, NIT at page, my lord, page 50, page 48, my lord. So, clause 14, my lord. The tender and the guarantor should mortgage the land against the value of the tender. They should obtain the Zamabandi for non-recompense certificate. The land to be mortgaged in the current year from the current deputy commissioner so and so, and clause with the tender. The guarantor should also put his signature in the tender papers, and document bank guarantee may also be filed with the tender and instead of document of tender property. Some land cannot be given in security of a same land cannot be given a security for the bazaar, ghat, Min Mahal, Pound, etc. The same guarantor tender will not be able to become the guarantor of the another bazaar, ghat, mahal. If there is a co-potader of the land intended to be mortgaged, the consent commitment, such potader should be enclosed with her tender. Consent and comment. Your lordship, kindly, if there is a co-potader of the land document to be mortgaged, the consent and content comment by such potters should be enclosed with the tender. That is the very mandate of the clause 14, my lord. Your lordship, kindly see here, my lord, his guarantor, his, my lord, affidavit, your lordship, kindly see page 87. Page 87, my lord. Page 87 has your lordship got it. That I am the owner and possess a plot of land measuring 22 bigha. So he himself said that, his guarantor said that I am the owner of this plot and possession of that plot of land. Now, my lord, your lordship, kindly see Jamabandi. If your lordship kindly see the Jamabandi, page 78. Page 78. From the Jamabandi, it is very much clear that he is the co-potader, my lord. There, along with him, there are 3-4, my lord, other co-potader, my lord. So it is, my lord, he cannot say that I am the absolute owner of that plot of land. If there is a, my lord, he is absolute potader, then no problem, my lord. But if there is a co-potader, there is a consent and, my lord, permission from the those person has to be annexed, my lord. So those are the defect, my lord, that is detected while producing all the record before this honorable court. The learned single judge granted the record. That's why, my lord, is a clear terms, my lord, learned single judge said that in para, my lord, 11 of the judgment, my lord, be that as it made, the court has the notice that deficiency document in the both the bid of the petitioner and Muhammad Mukhtar Hussain as well as the private respondent. The difference of the price of difference is 18 lakhs. So price is also 18 lakhs, my lord. And now honorable learned single judge detect that, my lord, from the record that, my lord, there is a deficiency in the both the, my lord, tender. Both the tender, my lord. So that's why, my lord, send back to the authority to consider invoking clause 10. Because clause 10, my lord, is not yet in the finality. Because there are two conflicting judgments. The latest judgment is along justice Madhi, my lord. So And very clearly, my lord, in their settlement, my lord, it is mentioned that their settlement is subject to result of the writ petition dated so and so, so and so. So that petition is now being withdrawn. There is no next. So, my lord, that's why, my lord, very rightly, my lord, but now, my lord, authority will decide. There is authority will decide, my lord. So, if there is a deficiency, he is also get a chance, my lord. If there is a deficiency in my lord, I also giving a chance, my lord, by invoking clause 10, my lord. Because your lordship, my lord, see that while decided this judgment was pronounced, my lord, that taken care of that even the order, my lord. So that's why am I submitting before your lordship, my lord. And 18 lakhs rupees, that is also very, my lord, the public interest is involved, my lord. Now already, my lord, notice has been given. I have produced all my documents. I have given, my lord, that is all, the judgment has already been acted upon, not only in my case, my lord, in other also, my lord, other, my lord, other settlement also, my lord, they have issued notice, my lord.
No, but when this judgment was pronounced,
My lord. My lord.
in the imperial judgment,
My lord.
why then that stay order was still subsisting?
Yes, that is true, my lord. But there is a conflicting judgment, my lord. There is a conflicting judgment, my lord. In that was considered, my lord. Your lordship kindly see para 8 of the that Honorable Justice made his judgment. That is, my lord, WPC 4077/2022.
Where is that judgment?
That, my lord, not been produced, but it is reflected in the order, that, my lord. Because that Justice Chaudhary's judgment also, my lord, I have not received, my lord. But that judgment is earlier. That is, my lord, in WPC 6902.
No,
And
no, that's fine. Justice Chaudhary's judgment that we have seen.
My lord, but
Is there.
my lord,
But where is this other judgment? 4377.
that is not with me, my lord. But that is
You have a copy?
Where are you? I'm looking into.
we mentioned it.
একটা copy. একটা copy. আমার copy নাই। I'm having a second copy also. I don't have copy.
You don't have another copy?
Two copies are there.
You have a copy?
No, my lord, I don't have a copy, but
জানি তো। আমার কাছে কপি আছে নাকি দেখো
Finish a copy to him also. Let him see both the 69, what is it, the other one?
one is 6902, other is 4377.
6902 4377. Finish copy. Then only we can proceed.
My lord.
ঠিক আছে word by word similar.
Yes, my lord.
Word by word similar. ওইটা না এটা ওখানটা ওখানটা
That is Manish.
হ্যাঁ মনীষ চৌধুরী এটা আছে কিন্তু এটু নাই না
We have to go to both his judgment.
My lord.
We have to go to both his
My lord. No, my lord, why I am submitting, my lord, in their, even today, my lord, your lordship kindly see in that their settlement order very clearly mentioned that their settlement is subject to, my lord, result of.
No,
that's me. So, and my lord, deficiency, my lord, that is by perusal, after perusal of the record, my lord, the deficiency found in the respondent by the appellant tender also, my lord. So that's why, my lord, that send back to the authority to verify and applying clause 10, you do this. And accordingly, my lord, that the judgment is already acted upon. Notice issued to me, my lord, I have produced all the documents.
You have a copy of 4377?
40,
No.
no, my lord.
Give him a copy.
That
then
is-
Right.
we can discuss
I only-
some other day we can.
Some of that.
All right, Chamra. Tomorrow, day after, my lord, Monday, my lord.
Monday, I think.
And in the meantime, my lord, the authority may not issue the settlement order. Because last time,
Now the authorities are taking care of your.
Yes.
So, so should we know.
Now, 30 is an earning, my lord. 30, my lord.
But Mr. P.T. sir, the city council,
uh,
assisted by Mr. D. Kaivo.
yes,
The appellant also had the T.J. Mata, that the city council, assisted by Mr. T.D. Manda, you're assisted by? A.D. Shoduri.
A.D.
Only council. This phone number?
One.
one.
And Mr. TN, the standing council. Standing council.
Same. Both are connected. Actually, I mean, for
You
a
finish
case.
copies? You finish copies?
Yes, yes.
We'll list it on, 8.
My lord.
Eight, my copy. Eight.
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 8.
But in the meantime, my lord, the authority are redoing the exercise in the sense that they have called for the document. The documents have been given by him as the submission of the land.
Okay, in the meantime, status quo is not.
Yes.
Item 44, isn't it?
Yes, item 44 and 45, my lord.
44,
Analogous.
44.
Uh,
Copy. Okay. Huh?
Item 46. 46.
44, no?
Or you pass separate. Separate. Don't make it. Two separate. Come on.
Wait, please, your lordships. My lord, this intra-court appeal raises certain questions of law. And before I take your lordships to those questions, let us have the facts, background facts in a nutshell. This appellant, writ petitioner, was appointed as the dean of the K.K. Hendick Open University. Dean of study centers. He was appointed for the first time. This is a tenure post, 5 years tenure. So first appointment was done on 3/11/2015, and he completed the term. And thereafter, there was a fresh advertisement issued again for the second term. So I was eligible, but my age has to be relaxed. They relaxed authority, and I applied for. There was a process of selection, and through the recruitment process, I was again selected, and I was again appointed. In that appointment letter, that is an advertisement says this is a tenure post 5 years. Law says specifically this is a tenure post 5 years. In the appointment letter, they put a clause that my appointment shall be subject to my death achieving the highest age of 60 years. I will have to retire at the 60 years. I raise a protest to that by filing an application also before the authority that this is against the law. Can you look into it? That is may not be proper. When my oral prayers didn't result, I had to submit a written application also. That also didn't result in anything. Ultimately, they issued me a letter of retirement. That look, you are attaining the age on such and such date, 60 years. So you will be retired on that day. I came against that order before this honorable. My specific case is that when the law specifically provides that this is a tenure post, 5 years, question of retirement doesn't arise there. Subject, of course, the highest age of 65, which is the cutoff. After 65, there cannot be anyone in the office. That is the law. So I say that you have advertised the post for 5 years. First appointment, that was a fresh appointment that was done 5 years. Second appointment, that is also a fresh appointment because this is not a re-employment or re-employment as such. Because I had to go through the process of selection again. And then I was appointed. Advertisement also says this is 5 years tenure post. How could you restrain it or apply that law that the age of retirement will be attracted to such an employee? The learned single judge has interpreted Rule 3 and Rule 9, reading conjointly, that it says that the 60 years should be the age for retirement, and therefore I am treated as an ordinary employee of the generally or ordinary employees retire at the age of 60. That has been the interpretation of the learned single judge, and says that this retirement notice was validly issued, and therefore I was continuing till the other day, taking advantage of this order of this learned single judge. Authority has said that since now the order has come, you are no longer in service since that day. From that day, when the notice was issued, I attained the 60 years. From that day, they have said that I am treated not to be in service. That is the position as on today. That's how the urgency arose, and I am before this honorable court. Now, kindly come to the next item. 123 at page, the learned single judge's order. Probably it appears at 124 page. My lord, we may skip over a few paragraphs, the facts, and the other side. Submissions have been recorded. My lord, here now, kindly come to regions and decisions at page 129. The provisions of the Act, the definitions have been quoted. Lordship will find page 130. Please come to who are employees there. All this has been quoted here. At page 130, my lord, officers of the university, first at the top, following shall be the officers of the university. 7, Rule 7 has been quoted. Dean Study Center, it was there. Then 12, it says, the dean, every dean shall be appointed in such manner on such emoluments and other conditions of service, and shall exercise such power and perform such functions as may be prescribed by the statute. This is there in the statute. So, as per statute, that has been done. Now, kindly come to paragraph 19, 132. I will read from there. Page 132. From the herein before extracted provisions of section 23(2) of the KKH SOU Act,
2005, it can be seen that the KKHSOU first statute 2009 was required to have been made by the Chancellor with the prior approval of the state government. The office of the Dean Study Center is referred to in Rule 9 of Chapter 5 of the KKHSOU first statute 2009. Accordingly, it appears that the incumbent holding the office of the Dean Study Center would ordinarily retire at the age of 60. The said rule also provides that the Board of Management, in the interest of the university, may re-employ any officer except the holders, kindly see this, may re-employ any officer except the holders of tenure post beyond 60 years, but not exceeding 63 years. Therefore, it prima facie appears that the condition imposed in the appointment letter dated 2010-2022, issued in favor of the petitioner by the registrar of the KKHSO University, cannot be said to be inconsistent with Rule 9 of the KKHO First Statute 2009. Rule 12 of the Ordinance number 8 also provides that the age of superannuation of officers would be at the age of 60 years. The post of Dean Study Center is an officer category post as per Section 7 of the KKHU Act. Rule. The court is of the further opinion that Rule 3 of Chapter 5 of the KKHU First Statute 2009 cannot be read in isolation of Rule 9 thereof. On a conjoint reading of both the said provisions which have been extracted herein before, it is seen that although Rule 3 of Chapter 5 provides that the term of office of registrar, the finance officer, the deans, and the director shall be 5 years, but they may be eligible for reappointment. Unquote. But Rule 9 thereof permits re-employment of an officer except the holders of tenure post. Here I am, but Rule 9 thereof permits the re-employment of any officer except the holders of a tenure post beyond 60 years, but not exceeding 63 years. The KKHOU Act 2005 and KKHU First Statute 2009 must be read in harmony because, as per the provision of Section 12 of the KKHU Act 2005, it has been provided that every dean shall be appointed in such manner, on such emoluments and other conditions of services, and shall exercise such power and perform such functions as may be prescribed by the statutes. Thus, from the provision of Section 12 of the KKHU Act 2005, it appears that the legislative intention was to give precedence to the statute. Insofar it is related to the other conditions of services, which is inclusive of the tenure of appointment. Therefore, as the condition contained in the petitioner's appointment letter dated 2010-2020 issued by the respondent number 2 cannot be said to be a condition that has arbitrarily imposed on the petitioner by unfair and or superior bargaining power of the university. Accordingly, the case of Arun Kumar Roy is found to have no application in this case. The Board of Management, in the proceedings of its 59th meeting, well, before going to this, kindly pause for a moment here. This interpretation of the learned single judge, that conjoint reading of Rule 3 and Rule 9 makes it clear that officer is to retire at the age of 60. And court has said that there is a provision for re-employment. The learned single judge has misconstrued and misinterpreted the words re-appointment and re-employment. This has two different connotations. Reappointment is one thing, re-employment is another thing. A person is already on employment. He can be re-employed. A person has completed his term. He has become functus officio. Then he is to be reappointed. the clear meaning is very apparent. Here is a tenure post. Kindly see what is the purpose of a tenure post? Who are those officers who are appointed as against those tenure posts? Those officers are vice chancellor, registrar, deans, director, those who are holding those offices for a particular period, and they are the persons normally brought in by way of deputation or by way of press appointment for a particular tenure. I was the person working in the college as an assistant professor, and thereafter I applied for, and I had to forgo that post to join here because my lien was ultimately extended to a certain period, not beyond. So first term when it was over, second term I had to give up that. I came here for another 5 years against that post. And therefore, if I am to be reappointed, I can be reappointed only by following the process. That's how the university process the whole procedure. They issued a fresh advertisement and I was allowed to participate there. I participated and I was selected and I was reappointed. It amounts to a fresh appointment for the second term. Re-employment is one when one is already in the regular service, his retirement is due, authority finds that he may be re-employed for a certain period extension, that by extension he can be granted. He need not have to go for a fresh process of selection. He is not required to go. Therefore, firstly, that confusion and kindly see rule 3. Rule 3 has been quoted. Now kindly come to these quotations in the judgment itself. Page 131, Lordship may kindly come to.
You don't have a copy of the act?
Yes. We have the act, my lord, probably.
We go to the act.
Yes.
Or
Lordship's extra copy of Maharashtra. My lord, this is slightly marked. Lordship will kindly bear it. Kindly first see this. I have already marked it. Yes. Book, my lord, that act. I'm sorry, my lord, I have only one copy.
well, we have an extra copy.
These are not found ordinarily in market. My lord, probably university authority can distribute copies to us. Otherwise, not available.
Your client can
Client doesn't have access to it.
He
So
has worked for so many years.
kindly come to that Malad chapter 5 at page chapter 166, my lord, in that book. Chapter 3, this is the first statute. Chapter 5, rule 3. Chapter 5 is for the officers. Manner of, it says, manner of appointment of registrar, finance officer, dean, and directors of the university, their emoluments, condition of service, powers, functions, and duties. This is the heading. Chapter 5, then rule 3. Rule 3 says, term of office. The term of office of the registrar, the finance officer, the deans, and the directors shall be 5 years. Very categorical, Malad. Shall be 5 years. But they may be eligible for reappointment. Kindly mark this, Malad. Reappointment. Then 9, Lordship may see. Rule 9. Page 80. Rule 9 at page 80, my lord. Lordship got it, my lord? Yes. The officers mentioned above shall ordinarily retire at the age of 60, provided that the Board of Management in the interest of the university may re-employ any officer except the holders of the tenure post. Here, except the holders of the tenure post beyond 60 years, but not exceeding 63 years. If it is satisfied that such re-employment is absolutely necessary for the interest of the university and not the officer, and that the officer is certified to be fit mentally and physically by a doctor of medicine of a medical college of Assam, not below the rank of associate professor. However, such re-employment shall not be made for more than 1 year at a time. Now, kindly see, the statute prevails over all ordinance and everything. This is the law which rule. Now it says manner of appointment, registrar, finance officer, deans, directors of the university. Their emolument conditions. That is before Rule 3. That is the heading. And specific clause 3 says the term of office of the registrar of finance officer, the deans, and the directors specified. All these are only these officers. Registrar, finance officer, deans, and the directors shall be 5 years, but may be eligible for reappointment. Now, rule says officers mentioned above retire at the age of 60, provided that the Board of Management in the interest of the university may re-employ any officer except the holders of the tenure post beyond 60 years. That means those officers who will be retiring and who could be re-employed, from that group, the tenure post holders are excluded. Logical conclusion, logical interpretation, purposive interpretation would be the intention of the authority to see, reading with 3 and 9, that the officers who will ordinarily retire, those who have the date of retirement fixed on the date when they join the service, they may be re-employed, but in that group, this tenure holders, tenure post holders are not included. They will be excluded from this because their specific term is 5 years. And now, kindly see, next 12, Rule 12, superannuation and re-employment of officers. In case of Rule 3, Lordship has seen, it is re-appointment, not the re-employment. Rule 9 says it is re-employment. These two terms distinctly used by the legislature. In Rule 3, it says, but they may be eligible for reappointment. So also I was reappointment. It was done by following the process of selection again, fresh selection process. He is not in service, that means. He has to be appointed again. And so for those who are in service, who had their date of retirement fixed on their joining itself, they may be considered for extension for 63 years up to 1 year at a time, not beyond. But from that group, the tenure post holders have been put aside. They are not included within that group. Learned Single Judge has brought in that no, it would cover the tenure post holders also. Here in my respectful submission, the Learned Single Judge has altered. The interpretation is wrong in my respectful submission. Ordinance 8 has been again quoted. Kindly come to page
134.
134. Ordinance which follows the statute. Come on, page 134. Ordinance 8. That has been quoted at page 131 also. Yes, now in the book, Lordship will find it at page 134, Ordinance 8. It says, Ordinance on recruitment, service condition, workload, and leave rules for professors, readers, regional directors, lecturers, assistant regional directors, and other officers of the university. This is the heading.
Ordinance 8, Rule 12.
Well, ordinance 8, my lord, at the beginning, lordship will find this heading at page, ordinance 8, page
134, it is rule 12.
wall 30, we'll go to rule 12.
Yes.
Here, lordship will see, this is an ordinance on recruitment, service condition, workload and leave rules for professors, readers, regional directors, lecturers, assistant regional directors and other officers of the university. Deans are not included here. Deans are not included here. And then 12, rule 12 says, superannuation and re-employment of teachers. Teachers, officers, and other employees will retire at the age of 60 years. The university can consider re-employing a superannuated teacher according to the existing guidelines framed by the UGC. This is rule 12. This rule specifically means the officers who has to retire attaining the superannuated age. For them. Therefore, now kindly come to we have referred to, we did refer to Ordinance 7 also, but that was not referred to, was not discussed. Kindly come to Ordinance 7 at page
121.
121.
121.
Ordinance 7, 121, my lord. 4,
Three.
Ordinance 7.
Three.
Rule 3, sub-rule 4. Ordinance 7. Lordship got it, my lord? Ordinance on appointment on contract basis or fixed tenure contract basis. Here it says, Ordinance 7. Ordinance on appointment on contract basis or fixed tenure contract basis framed under section 23(1)D of the KKHU Act. Here it says that the contractual appointment could not be made beyond 65 years. This is the maximum age limit of an employee fixed by the law. This is the maximum age limit. Beyond 65, nobody can be there in contractual or in tenure post, and in regular employment, those their case is 60 years. Retirement age is 60 years. 60 years. The learned single judge has not discussed this. Now, kindly come to the impugned judgment. These things have been interpreted in a way which has frustrated the whole purpose. At page 131, Lordship will kindly come to now, impugned judgment. How the learned single judge has reasoned it, let us see that. Paragraph, I will read from paragraph 17, my lord. Yes. The learned senior counsel for the petitioner has laid much stress on the provision of Rule 9 of the KKSU First Statute 2009, specifically on the words, except the holders of the tenure post, quote unquote. It was emphasized that the petitioner was given a fresh appointment to the post of Dean Study Center, which cannot be considered as re-employment. 2, that the said words except the holders of the tenure post excludes tenure post. The said contention has been considered and would be answered later. It may be mentioned that Annexure 3 to the writ petition is a photocopy of the advertisement number so-and-so, inviting applications for the post of Dean Study Center. Appended to the said Annexure 3 is a sheet containing qualifications and requirement. And in the paragraph relating to requirement of age, it has been mentioned as follows. Age should not be more than 55 years as on the date of application. However, the university reserves the right to relax the upper age limit for deserving candidates. This condition was there in the advertisement, and I took resort to this. Therefore, I was exceeding 55 years by few months or so. So authority relaxed it, and I had to apply. I could apply only on relaxation. So granted. From the herein before extracted provision of section 23(2) of the Act 2005, it can be seen that the first statute 2009 was required to have been made by the Chancellor with the prior approval of the state government. The office of the Dean Study Center is referred to in Rule 9 of Chapter 5 of the first statute 2009. Accordingly, it appears that the incumbent holding the office of the Dean Study Center would ordinarily retire at the age of 60. This conclusion itself in my respectful submission is vitiated, not in accordance with law. It cannot be. The said rule also provides that the Board of Management in the interest of the university may re-employ any officer except the holders of the tenure post. Again it says, except the holders of the tenure post beyond 60 years but not exceeding 63 years. Therefore, it prima facie appears that the condition imposed in the appointment letter dated 2010-2020 issued in favor of the petitioner by the Registrar of University, Response number 2, cannot be said to be inconsistent with Rule 9 of the Act First Statute 2009. This again is an error committed by the learned single judge. Rule 12 of the Ordinance number 8 also provides that the age of superannuation of the officer should be at the age of 60 years. The post of Dean Study Center is an officer category post as per Section 7 of KKHU Act 2009. My full submission, my lord, Rule 12 was also misconstrued. The court is of the further opinion that Rule 3, Chapter 5 of the First Statute 2009 cannot be read in isolation of Rule 9 thereof. On a conjoint reading of both the said provisions, which have been extracted herein before, it is seen that although Rule 3 of Chapter 5 provides that the term of office of the registrar, the finance officer, the deans, and directors shall be 5 years, but they may be eligible for reappointment. But Rule 9 thereof permits re-employment of any officer except the holders of tenure post beyond 60 years, but not exceeding 63 years. The Act 2005 and First Statute 2009 must be read in harmony because as per provision of Section 12 of the Act, it has been provided that every dean shall be appointed in such manner on such emoluments and other conditions of services and shall exercise such power and perform such functions as may be prescribed by the statute. Now, statute has said specifically clause 3, clause 9, therefore 22 paragraph. Thus, from the provision of Section 12 of the Act 2005, it appears that the legislative intention was to give precedence to the statute. Insofar, it is related to the order, other conditions of services, which is inclusive of the tenure of appointment. That is true. Statute will find precedence, and statute specifically says it shall be 5 years tenure post. Therefore, as the condition contained in the petitioner's appointment letter dated 2010-2020 issued by the Response number 2 cannot be said to be a condition that has arbitrarily imposed on the petitioner by unfair and or superior bargaining power of the university. Accordingly, the case of Arun Kumar Roy is found to have no application in this case. Here in this case, Mr. Arun Kumar's case, that point was there that the authority, certain conditions were incorporated in the appointment letter, and thereafter it is found the benefit was sought by the employee, that as per those terms, I should be given the benefit. Supreme Court interpreted that no, when the rules are specific, you will get as per the rules, not otherwise. So condition incorporated in the appointment letter, that is not binding, but the rule, when the rule provides for, that is binding on all the authorities. So this is there, my lord. Sorry. 23. The Board of Management in the proceeding of the 59th meeting held on 19/10/2020 did not specify the age of superannuation of the petitioner. The board had merely directed the appointment letters to be issued as per the terms of appointment under the university rules. Thus, the registrar had issued the appointment letter dated 20/10/2020, prescribing therein that the age of superannuation would be 60 years. It is reiterated at the cost of repetition that the provisions of Rule 9 of Chapter 5 of KKSU First Statute 2009, as well as Rule 12 of the Ordinance number 8, prescribes the age of superannuation of officers, which includes the post of Dean Study Center, to be 60 years. Lordship has already looked into Rule 12 and Rule 9. It doesn't include, in my respectful submission, this excludes, Rule 9 excludes specifically the study centers deans or tenure post holders. Therefore, the condition contained in the appointment letter dated such and such that the petitioner would superannuate on attaining the age of 60 years cannot be said to be inconsistent and or contrary to the first statute. Therefore, in light of the discussion above, the first issue raised by the learned senior counsel for the petitioner, emphasizing that the petitioner was given a fresh appointment to the post of Dean Study Center, which cannot be considered as re-employment, is answered by holding that the notwithstanding that appointment of the petitioner for the second term would be a circumstance which is nothing but re-employment of the petitioner. That is the finding of the learned single judge. It says that I am re-employed, as if I will continue as a regular employee of the authority under the university, and so the regular age of appointment, 60 years, will be applicable to me. The second issue raised by the learned senior counsel for the petitioner as to whether the words, quote unquote, except the holders of the tenure post appearing in Rule 9 of the first statute excludes tenure post, is answered by holding that the provisions of Rule 9 of Chapter 5 and the first statute 2009, read in harmony with Rule 12, Ordinance 8, makes it clear that the age of superannuation of officers, which includes the post of Dean Study Center, is 60 years, with further prescription that the age of superannuation cannot exceed 63 years. Here also, as the learned single judge has failed to take note of Ordinance 7, we have already shown that in such contractual tenure post holders, they cannot go beyond 65. Maximum limit is 65, not 63. Thus, the condition contained in the appointment letter so and so to the effect that the petitioner would superannuate at the age of 60 years cannot be said to be inconsistent or contrary to the Act 2005, First Statute 2009, and Ordinance 8, recruitment, service condition, workload, leave rules, process, so and so, so and so. Moreover, 27, as per document annexed to Annexure 3 to the writ petition, the age of the applicant was required to be 55 years, which means that the age of superannuation was envisaged at 60 years. Well, this speculation of the learned single judge is baseless, with all respect. I am coming to it. It says, because the age of applicant was required to be 55 years under the advertisement, which means that the age of superannuation was envisaged at 60 years. This is the interpretation of the learned single judge. By the said document, the university had reserved the right to relax the upper age for applying for the post of Dean Study Center. Therefore, the indelible impression of the court that that in this case, university had taken a conscious decision to accept the candidature of the petitioner. And as per the legal requirement discussed herein before, ascribe the age of supervision of the petitioner on his attaining the age of 60 years. Well, the appointment letter, the advertisement letter says the candidate maximum age for the candidate 55 years. Learned single judge has interpreted that this means it was in the mind of the appointing authority that only 5 years, one will be appointed only for 5 years. Therefore, 60 years will come, 55, 60. So when they issued it, their intention was very clear that it will be retiring at the age of 60. Whereas Lordship has seen Ordinance 7 says that they can retire and work up to 65 years. Such employees can continue up to 65 years. So if 65 years, 55, 2 terms one will get. 2 terms one will get. That is, that consideration has been forgotten by the learned singular. So merely fixing that 55 says, so therefore it means 5 years term, 60. You cannot go beyond that. That is the intention. That is wrong. In my assumption, that is wrong. Because Ordinance 7 again says that they can go up to 65. And if we consider from that angle, 55, 65, another term one will get, he may, if he is so selected again, 65. Therefore, this speculation of the learned single judge in municipal service is wholly unfounded. Thus, the condition contained in appointment of so-and-so is not found to be arbitrary or inconsistent with the prescription of age contained in the said document, advertisement, and Excerpt 3. In terms of the decision, Supreme Court of India, in the case of Sumesh Thaprial, the court is not inclined to dismiss the writ petition on the ground of delay on part of the petitioner to assail the conditions contained in the appointment letter of so-and-so. As per the facts of this case, the delay on the part of the prisoner in approaching the court would not be fatal. Nonetheless, in light of the discussions above, the court is of the unhesitant opinion that the condition 2 contained in the appointment letter of the petitioner bearing reference so-and-so dated 20th October 2020, prescribing the term and or tenure of appointment to the office of the Dean Study Center for 5 years or till attainment of 60 years. This was the challenge, my lord. It was said 5 years or till attainment of 60 years, whichever is earlier, is inconsistent and or in consonance with Act so-and-so or First Statute so-and-so, being Ordinance on Recruitment Service so-and-so, Assistant Directors and others so-and-so. They say it is consistent. So therefore, my submission is prima facie, the interpretation so given by the learned single judge is not consistent with the objects and purpose of the act, and also it is totally irrelevant considerations were taken into account, and interpretation is not proper and not fair. Therefore, Lordship may be pleased to examine this. Meanwhile, my lord, situation is that I was working by virtue of the order of this Honorable Court, learned single judge. Now they have issued a letter after this that you will be treated to have retired on the date when you received the notice, where the date fixed. But I was continuing, otherwise my tenure will come to an end only in 2025. 2025, my tenure will come to an end. So I will request that there should be an interim order to take me, allow me to continue the Dean until a final decision is given by this Honorable Court in the writ petition. They have filed a caveat, they are opposing it. They are here to oppose my interim prayer. But in my response submission, Lordship will kindly consider the balance of convenience is in my favor. Interpretation, law will be laid down by this Honorable Court finally. I am continuing, I was continuing, I am deemed to be continued in service. This honorable court allowed me to continue. My term exists till 2025. Therefore, Lordship will grant me this benefit. It will be in the interest of the university only. I am serving, giving my service to the university. Otherwise, if I am out, I will be nowhere. I have left my original job. I have left my original job. I have come here. That at least another 5 years I will be there. Now I will be out. No. Therefore, it will cause prejudice, serious damage to me. That's my respectful submission. Lordship will kindly pass.
My pleasure. Well, regarding the notice, I have no objection, but regarding the interim period, I have a serious objection because of the fact, my lord, it will have a lots of bearing. Apart from the other, my lord, there is a financial burden on the institution also. Because of the interim order, already there is a nearly, my lord, 26 lakhs has been additionally paid in spite of the fact that he should have been retired at the age of 60, my lord, on 2022 itself. And because of the interim order, he has continued till the 1 year, few months. Now, because of that continuation, the university has paid him 26 lakhs for that period, for 1 year. And now we have to recover also, my lord, if it is absolutely illegal. That's why, my lord, I'm saying we have allowed to continue. There will be an additional burden to the university concerned. Now, going back to the legal factual matters, my lord, the university have two different categories of the officers as per the statute is concerned. Lordship, I'll just like to draw Lordship attention to the page 13 first, my lord. 1-3 of the yellow book, my lord. Lordship can page 13. As for our university, there are two kinds of officers. Now, the officers of the university, now Lordship can see the 7. The following shall be the officers of the university. The page 13, my. The chancellor, the vice chancellor, pro-vice chancellor, register. Number 4 onwards, Lordship can see the register, dean, dean administration, the dean study center, the finance officer, the 9, the directors, the multimedia courses and material center. Then the director's computer, 11, and the such other officers as may be declared by the statute to be the officers of the university. Now, these are the 11 categories. These are considered to be the officers of the university. Includes the dean of the study center. No dispute about it. So he is firstly, he is an officer of a university. His first category. Now where from he is superannuated? From our university. No dispute about it. He is superannuated. What is the condition for the superannuation in our university? The condition precedent is the 60 years for all. Now, Lordship kindly see the next, my lord, page 134. My lord. So it's a part of Ordinance 8, my lord. Page 134. It's a part of Ordinance 8. 12, my. May I read, my? Superannuation and the re-employment teachers, the teachers, officers, and other employees will retire at the age of 60 years. Now, teachers and the officers. So, Lordship kindly see, he is also an officer by virtue of 7. Rule 3, number 7. He is an officer, first of all, so he has to retire at the age of 60, my. That's very clear. First of all, he is an officer and he has to retire at the age of 60. And then next, my lord, the university can consider re-employment. A superannuated teacher. So where he is from superannuated, my lord? From the university. So he is superannuated from our university. He is not from the somewhere from else, my lord. This man is from our university. He is superannuated at the age of 60 years. So he can be again re-employed teacher according to the existing guideline and framed by the UGC. Now, the what are the other guidelines the statute has provided now? Let us see, my lord. Now, Lordship, kindly see the page 80. This is very clear, my lord. Here also, Lordship will find all the officers 9. Now, Lordship, kindly see 9. The officers mentioned above. Now, who are the officers mentioned above? Lordship, kindly go. Let us go back once again, man. It will clear everything, my lord. To start from, my lord. He falls under D. Chapter 5, Lordship, kindly see, page 65. Chapter 5, page 65. The manner of appointment of register, finance officer, deans and directors of university, their announcements, addition services, condition of services, power, function and duties. Manner of appointment. Now the term of office, now Lordship, please kindly see. The term of office of the registrar, finance officer, the dean and the director shall be 5 years, but they may be eligible for reappointment. Now, A is the registrar, then the B is the finance officer, D is the dean, E is the director multimedia, F is the director computer, G is the other officer. So, we fall under the D, page 70. So, as I said before, these are the officer as mentioned above will retire at the age of 60. So, these officers also will retire at the age of 60. Dean also has to retire at the age of 60. But apart from there are other officers, as I said before, because university has other officers, the vice chancellor, the pro vice chancellor, then the the chancellor. They are also considered to be the officers of the university. Now, the officers mentioned above shall ordinarily retire at the age of 60. I'm reading from page 80, my lord. The officers mentioned above shall ordinarily retire at the age of 60, provided that the Board of Management, in the interest of university, may re-employ any officer. So, officer who is retiring at the age of 60, they can be re-employed beyond 60 years, but not exceeding 63 years. So, you read the bracket. I'll come to that. I'll come to that. So, why this? Except the holders of the tenure of the post. So, who is having the tenure post, they cannot be anyway employed beyond 60 years. So, who is having the tenure post, if he has attained the 60 years in the university, they cannot be by virtue of any way because of there's a specific bar. That is why this exception has been brought in. Why this is the exception, my lord? Retainer post. This is the exception because all the officers, they can be construed.
University, but it's a term of these three officers, registered finance officers and the deans. And the directors. Term of the other officers, there is no term of office. That you, all the officers.
So my contention is very clear, my lord, from the learned Singhal also has clarified very clearly, my lord, that these are the officers who's holding this tenure post. They cannot be re-employed, who are superannuated at the age of 60 at any cost in the university.
Let us go back to 3.
Yes.
Rule 3.
Rules. This is a tenure post, my lord. No doubt about it. Page
66.
66. Yes, the term of office of the registrar, the finance officer, the deans and the directors. So there are other officers also, but these specifically, my lord, the registrar, the finance officer, dean and director shall be 5 years, but they may be eligible for reappointment. So reappointment, they can be eligible. But we have to read it with conjointly with the 12, Ordinance 12. Ordinance 8, Rule 12, my lord. Rule 12 says all officers has to retire at the age of 60. All officers, man. All officers, well, page 134. An university can consider re-employment of a superannuated teacher according to existing guideline framed by the UGC. Now, the superannuated teacher, he is already superannuated. Now, the sum of the teachers who does not fall within this category, my lord, the tenure post, he can be considered. That is why this is the distinction, my lord. Am I clear, my lord? The sum of the officer who does not fall within the tenure post, they can be considered again in spite of the attainment of the 60 years. So they can be, but their appointment also only up to 63 years.
You will admit this.
I have objection regarding the interim.
Sir, we're not convinced. Because you just saw,
Well,
apart from this 4 officers,
yes,
finance officer,
yes,
register, dean and directors,
yes.
who are the officers who are having the tenure?
They are only having the tenure post. Rest are not having the tenure post. Right?
Therefore, it's a tenure post, you cannot cut it.
So
On the
tenure
basis of,
post,
retirement.
the tenure post, the other officer,
No,
Was-
what was the necessity to issue an advertisement then?
the advertising lordship, that is why I say it, my lord. Even then, lordship kindly see one thing. In the advertisement, we have specifically, because the rule says everybody has to retire at the age of 60. Because they all officers. He is he is also an officer, first of all. There's no doubt about it. So as per the rule, as per the ordinance, he has to retire at the age of 60, my lord. But there are some tenure posts in the university. The 4 categories of the tenure post. There are fixed period of 5 years, generally. But the otherwise, this 9 and 12, what it says, my lord, every officer has to retire at the age of 60. Now, he falls within the category of 60, my lord.
That's why there's a difference of officers having a tenure post or.
Yes, my lord.
normal
So in a tenure post, so he is also having a tenure post.
tenure post.
No
There's
doubt about it.
Separate advertisement.
But no, my lord. He is having a tenure post, separate advertisement. Therefore, in the advertisement, we have a specifically mentioned whichever is earlier.
It's a reappointment, eligible for reemployment. It's not a question of reemployment.
No, my lord. He has superannuated from our institution, my lord.
I think prima facie, this, your ordinance
Yes.
relates to the officers doesn't have, who doesn't have the tenure post.
No, my lord. Lordship kindly see.
Ordinance 8
Yes, my lord. The 8.
and the 12.
8 says, what 8 says, my lord?
Third, Mr. K.K. Manda, Leonard Senior Counsel, assisted by Ms. N. Begum, Leonard Counsel for the appellants. Admit. You are praying for the.
One and two.
1 and 2, Mr. M. Bora, Leonard Senior Counsel, assisted by Patore, J. Patore, Leonard Counsel, appears for the respondents 1 and 2. Any other respondents? Assam?
Assam.
And S. Bhuya, Leonard, Standing Council, Higher Education, appears for respondents. We'll have it disposed at an early date.
Yes. Well, that's why I'm saying, my lord, let us dispose of in the next date, my lord, because otherwise, if it continues, it will create a burden for the institution, my lord. Already there's a burden of 26 lakhs, my lord. That is why let us dispose of in the next month. It will clear everything. Otherwise, again, if it is accumulate, my lord, because otherwise we have to, that's why let us dispose of the matter in the next month itself without any interim, my lord. The final disposal.
This is the matter. When do you want? Give a date.
I leave it to your lordship's, my lord, as per convenience, lordship may fix it. For disposal, I have nothing to do, but then question is, my lord, submission is as if the post is going to be abolished, no one is going to be taken there, and so it is a burden paying. I am,
Burden definitely 26
I am
lakhs. has
rendering
already we
service,
have
I
to
am
pay,
paid
my
by
lord.
salary.
No.
The matter for hearing on, we'll have it in February itself.
My lord.
No.
The
my
last
lord,
part of the February,
In
my lord.
March, my lord. Lordship will take it in March. Second, third week, March.
Second,
Second,
Lordship may fix it.
12th March.
Yes.
12th March.
Absolutely,
Yeah,
no?
12 March.
Yes.
We'll stay this order. In the interim,
Well, I have my objection, maybe,
yes.
interim, my lord. That may be considered on 12 also, my lord.
No, my lord. Lordship will put me back, my lord. I will.
No, because you are not going to appoint anybody and
The judgment order dated 19/1/2024. Passed in WBC 8310 of 2024 shall remain suspended.
Lordship may kindly clarify, the petitioner will continue to
In other words, the appellant shall continue as dean within bracket
study center
study center
of the university.
of the what university is it?
It is KK Hendrik
Hendrik
Open University,
State Open University.
KKH SOU.
State Open University.
Just say of Krishna Kandi Hendrik State Open University.
Open University. Deep level. Deep level.
Item 47.
Book to level, no?
May it please your lordship.
My lord, in any tender process, there is a technical evaluation as well as a price bid is looked into. Here, my lord, the private respondent technical bid was rejected. Against that, my lord, he came in before the learned single judge. When the interim order was refused, he went to the division bench. Division bench again remanded the matter. Then to the learned single judge, the learned single judge then allowed his repetition, and I am the successful bidder. My prayer has been rejected. Your lordship will first look into page 71, what is the work about. It is Your lordship will look into page 71. Your lordship will kindly take note of the date, that is 11th April 2023. This date is relevant because any work which has awarded in favor of any of the parties has to be disclosed. So any work which is from prior to 11th April 2023 has to be disclosed. Then your lordship will find that the name of the work it's a national highway work, periodic renewal of Makum Rupai bypass from 00 to kilometer 23.482 L kilometer. Then your lordship will find that the estimated cost is 19 crores and 29 lakhs. The completion period was 12 months and maintenance period was 3 years. Then your lordship will see in that page itself under clause 2, the second paragraph, the completed bid document can be viewed, downloaded from official portal of the CPP website so-and-so. Bidder must submit his financial bid and technical bid at so-and-so on or before 11/5/2023 up to 1400 hours. Bid received online shall be opened on 12/5/2023 at 1400 hours. And in the next paragraph, your lordship will also take note of the line number 3. Please note that the ministry, authority, executing agency reserves the right to accept or reject all or any of the bids without assigning any reasons whatsoever. Now your lordship will see the impugn order at page 171, how the bid has to be evaluated, my lord. And this is the minutes of the technical bid evaluation committee held on 14/6/2023. My lord, we will continue at 2.
Let me sorry to mention item number 21 and 22, my lord. Which are on the other side, my lord, I am paying for like it matter be taken up in the next, in the next week or in the.
When do you want?
After, let it be after 2 weeks, my lord.
Yeah, request by the parties. You did with the consent.
Oh, the consent.
List after 2 weeks.
Bless you, lord.
Item number 15, my lord, can be taken up on 8th of February, my lord. I've taken consent from the other side.
You are praying for?
I'm for respondent number 1, my lord.
Your good name?
R. Chakraborty.
Okay, on request made by R. Chakraborty. List on 8.
May I pray for fixing it date, lord?
After we get
8.
Yes. May it please. Well, prior to the break, I was trying to draw your lordship's attention to Annexure F at page 171, which is the minutes of the technical bid evaluation held on 14/6/2023. 171, mile. Now, if your lordship will just skip the first page, because this again already I have referred this bidding process and all, your lordship will see the grounds of rejection of the respondent number 1, that is at page 172 at clause number 3, my lord. Purbanchal Buildtech Private Limited, who is the respondent number 1 in this writ appeal, my lord. Based on the representations, my lord, this representation was submitted by me
I will take to your lordship to those representation after I finish this paragraph, reading this paragraph, my lord. Based on the representation received regarding the concealment of existing commitments by the bidder, namely Purbanchal Buildtech Private Limited, necessary clarification were requested from the relevant heads of the directors, specifically CPWD Border Roads, through TO letter number dated 25/5/2023. I'll take your lordship to that letter also. These works were under PWD National Highway, so there was other works of this organization going in PWD border. In response, the CPWD Border Roads Assam through letter number so-and-so dated 26/5/2023 has confirmed that the bidder did not disclose the mentioned commitments in their bid. This deliberate misrepresentation of fact, well, this is the ground on which it was rejected. This deliberate misrepresentation of facts renders the bidder liable to be disqualified as per clause 2.6.2 of the request for proposal RFP, and the bid security shall be appropriated accordingly as specified in the clause. Consequently, the bidder is considered technically non-responsive. Now, before I take your lordship to those representation, let me take your lordship to this clause 2.6.2 at page 94. Page 94, my lord, clause 2.6.2 and 2.6.3, both are relevant, my lord. The authority reserves the right to reject any bid and appropriate the bid security if at any time a material misrepresentation is made or uncovered. This was the clause which was invoked in this case. At any time a material misrepresentation is made or uncovered, then next paragraph your lordship can omit, then your lordship will read 2.6.3. In case it is found during the evaluation or at any time before signing the agreement or after its execution and during the period of defect liability subsistence thereof, that one or more of the eligibility and or qualification requirements, this is important, my lord, one or more of the eligibility and or qualification requirements have not been met by the bidder or the bidder has made material misrepresentation or has given any materially incorrect or false information, the bidder shall be disqualified forthwith if not yet appointed as the contractor either by issue of the letter of acceptance or entering into of the agreement. And if the selected bidder has already been issued the LOA or has entered into the agreement as the case may be, the same shall notwithstanding anything to the contrary contained therein or in this RFP be liable to be terminated by communication in writing by the authority to the selected bidder or the contractor as the case may be, without the authority being liable in any manner whatsoever to the selected bidder or the contractor. In such an event, the authority shall be entitled to forfeit and appropriate the bid security or performance security as the case may be. Then your damages without prejudice to any other right or remedy. That is the clause which is there. Now your lordship will see the representation that was submitted by me initiating this process was at page 244. Well, this was given to the chief engineer of PWD National Highway Works Assam. And I had given this representation not only against the respondent number 1, Purbanchal Builders Private Limited, against 2 other contractors also. There means one other contractor, that is HK Hatiboro and Company. Now your lordship will find, dear sir, with due respect, I have to inform you that I have participated in the above mentioned tender with the other 5 numbers of contractors, namely so-and-so, for the work of so-and-so. But it is great unfortunate that 2 numbers of contractors, Mohammad Matlebuddin Ahmed, house number 2, Hawalipot so-and-so, now changes Messrs. Purbanchal Builders Private Limited, so-and-so, have hidden their ongoing works as mentioned at Annexure 1 enclosed, which is a great infringement of the tender as per clause 2.6.2. Now, the work that has been hidden is at page 245, my lord. The 3 work which were not disclosed in the tender document were this, my lord. Name of bidder, Mohammad Matlebuddin Ahmed, now known as Messrs. Purbanchal Buildtech Private Limited, under the chief engineer, PWD Border Roads, Assam, Sanmari, Guwahati 3. This is number 1 is upgradation of roads from MRL 04 RD, then upgradation of roads from so-and-so, then Govardhan Bazaar. Then your lordship will find at this site at the side column, the first work was yet to be started. Second is work in progress, and the third is yet to start, my lord. Then in response to this representation of mine, the chief engineer of PWD National Highway wrote to the chief engineer PWD Border Roads. That communication you also will find at page 246, my lord. To the chief engineer PWD Border Road, Sanmari, my lord. The bidder named Mohammad Motlibuddin Ahmed, now known as Messrs. Pulvanchal Buildtech Private Limited, has participated in the bidding process of the above mentioned highway work. Confirmation is required regarding the status of the following works under your department which have been awarded to the said bidders. Then those 3 works are given, and a request was made that the status of the above mentioned works may kindly be submitted from your good office at the earliest so that the same may be considered for evaluation of the bids. Then the reply comes at page, my lord, 247, the next page, my lord. So this is the PWD Border Roads has confirmed that the 3 works are allotted in the name of Motlibuddin Ahmed, and the status of the works were also given. Now your lordship will see how this format of the works which are ongoing or yet to start or where LOA have been issued. There is a format prescribed in the tender document. That format your lordship will find at page 127. Page 127, madam. Your lordship will look into the second paragraph, madam. The statement showing the value of all existing commitments, anticipated value of work to be completed in the period of construction of the project for which bid is invited and ongoing works, as well as the stipulated period of completion remaining for each of the work mentioned above, is verified from the certificate issued that has been countersigned by the client or its engineer in charge not below the rank of executive engineer or equivalent in respect of EPC projects, or concessionaire or authorized signatory of SPV in respect of BOT project. No awarded ongoing work has been left in the aforesaid statement which has been awarded to matchers. Now your lordship will see individually, stroke, and other members, messers, as on bid due day of this RFP. Now your lordship will see page number 281, this statement, my lord, which the respondent number 1 has submitted, my lord. Your lordship got page number 281.
Yes.
Now your lordship will see the statement. The statement is of for 5 years. Then your lordship will see the lines, madam. The statement showing the value of all existing commitments, anticipated value of work to be completed in the period of construction of the project for which bid is invited, and ongoing works, as well as the stipulated period of completion remaining for each of the work mentioned above, is verified from the certificate issued that has been countersigned by the chief or his engineer in charge, not below the rank of executive engineer or equivalent in respect of EPC project or concessionaire authorized signatory of SPV, irrespective of BOT project. Then your lordship will kindly look into this line. No awarded ongoing work has been left in the aforesaid statement, which has been awarded to Messrs. Motlibuddin Ahmed, Director of Provincial. So he has specifically mentioned that no awarded ongoing work has been left in the aforesaid statement, which has been awarded to Messrs. Motlibuddin Ahmed, Director of Provincial Buildtech Private Limited, individually, and other members, and Messrs. So-and-so as on the bid value of this debt. So your lordship will look that this is misrepresentation. Then your lordship will kindly see page number 347, the statement, my lord, at page 347, my lord. Your lordship got the page number 347. Now 347, your lordship will find in the row number 4, entity for which the project was constructed, where the value of his credential increases, he has shown in this entity for which the project was constructed that CPWD border roads and NEC works Assam Chanmari Guwahati 3. This means this is a work which is also under the border roads, but if you show this work, his credentials will increase. That's why he has shown this work in the format, but he did not show the other 3 works. Well, I'll come to that reason also. So to increase his credentials, one work of PWD border roads has been shown in the statement which was submitted along with the tender documents. Now your lordship will see why this is done. There is a test of responsiveness which is part of the tender document, my lord. Your lordship will kindly look at page number 104. Three point 1.6.1 is at the bottom, my lord. Test of responsiveness. As a first step towards evaluation of technical bids, the authority shall determine whether each technical bid is responsive to the requirements of this RFP. A technical bid shall be considered responsive only if technical bid is received online as per the format at Appendix 1A, that is page 116, including Annexure 1, 4, 5, and 6 bid capacity format. Now, your lordship will first, because I am referring to this Annexures Appendix 1A, Annexure 1, 4, 5, and 6. So I will just take your lordship for a moment in respect of Appendix 1A to page 116. Your lordship will keep this mark, page flag mark. My lord, I will take your lordship to page 116. We need 116. Sorry, but there's some confusion. My lord, it will be, sorry, my lord, my page number is 126. My lord, sorry, man, 126. Not 116, 126. It starts from 116, but the relevant annexure is at page 126, my lord. The document which I have referred at page number 347 just now has been shown at page 126, my lord. Your lordship will find this is the format. Information required to evaluate the bid capacity under clause 2.2.1. Calculate the value of A and C. My lord, C is normally in regard to some bonus, which is always 0 in most of the works of the PWD. Now, in the table, your lordship will find a table containing value of civil engineering works in respect of EPC project, turnkey projects, item rate, contract. Then your lordship will find the 5 works of the years that has to be submitted by the respondent number 1. And the work that I have referred at page number 347 just now has been shown in this format at page number 347 to increase his credential, my lord. Whereas, my lord, this work, these 3 works has not been shown in page number 127, that format, my lord. Now your lordship will look the explanation by the PWD in their affidavit. What was their explanation to all this at page 333? The PWD's affidavit, my lord. Because ultimately it is the tendering authority who is the bid judge of all these things, my lord. Page 333, my lord. Your lordship got it, page 333. Your lordship will look into the second paragraph. The petitioner company submitted, my lord, this Purbanchal, my lord, submitted 3 projects in details of eligible project, that is project code A, B, and C as the credentials of the company. Out of the 3 eligible projects shown by the BJP, project code B, that is improvement with widening and strengthening, including construction of RCC drain, so and so, which was allotted to and completed by Mohammad Matlabuddin Ahmed and the authority for which the project was constructed is CPWD Border Roads and NEC Works Assam, Chalmari, Guwahati 3, which substantiates the fact that the company Purbanchal Buildtech Limited inherited the credential of Matladuddin Ahmed for the first work, even outside the purview of CPWD NH work. So other than this NS highway also, this Matlabuddin Ahmed, who is the director of Purbanchal, has also acquired the credential of the PWD border roads, madam. Now, what was the explanation of the writ petitioner in regard to this not disclosure of pay, this 3 work that your lordship will find at page 47 in para 11 of the writ petition? Page 47, madam. Your lordship got page 47, paragraph number 11. That the petitioner has from reliable source have come to learn that while arriving at the aforementioned impugned decision, the tender evaluation committee relied upon some existing pending works in PWD border roads in the name of one of the directors of the petitioner's company, Mohammad Matlabuddin Ahmed. The said works were pending in the name of Mohammad Matlabuddin Ahmed in PWD border roads, Assam, and not in the name of the petitioner company. Further, unlike the office order dated 21/7/2022 issued by the Chief Engineer PWD National Highway Assam, whereby the existing pending works in PWD National Highway Assam in the name of Matlabuddin Ahmed was transferred in the name of the petitioner company, there is no any such order issued by the Chief Engineer PWD Border Roads transferring the pending works in the name of Matlabuddin Ahmed in PWD Border Roads to the name of the petitioner company. Thus, the said existing pending works in PWD Border Roads Assam in the name of Mohammad Matlabuddin Ahmed was not mentioned in the tender document submitted by the company. They may have admitted that it was not submitted. It is pertinent to mention herein that after issuance of the office order dated 21/7/2022, the ongoing works in PWD National Highway Assam, which have been transferred from the name of Mohammad Matlabuddin Ahmed to the name of the petitioner company, were duly disclosed in the tender document as the said works to transfer in the name of the petitioner company after the aforesaid officer. Thus, the respondent technical evaluation committee most illegally and arbitrarily and in an unjust and unreasonable manner declared the technical bid of the petitioner as non-responsive by taking into consideration some pending works in PWD border roads to which the petitioner company is no way connected, and hence the impugned decision in the minutes of the technical bid committee dated 14/6/2023, whereby the technical bid of the petitioner has been held to be non-responsive, is liable to be interfered. This is the specific bidding. Now your lordship will see when this was moved before the learned single judge and when an interim order was not granted in the favor of the respondent number 1 herein, but a writ appeal was preferred, and the order in the writ appeal your lordship will kindly look into. That has relevance in this case. Your lordship will look at page number 352. It starts from 350, but the relevant portion is at page number 352. The order starts from page 350, but your lordship will the division, page 352, the Honorable Division Bench has granted full liberty to the PWD to take additional recourse also other than the what is reflected in the minutes of the tendering document. Your lordship will look at paragraph number 4. On the request of Mr. D. Nath, it is further clarified that the tendering authorities will be at liberty to take recourse of clause 2.6 of the tender conditions for seeking explanation, additional information from the parties if so advised. So liberty was given to the authorities to invoke clause 2.6 and also to seek for explanation, additional information from the parties if so advised. Now, the PWD in pursuance to this order, if your lordship looks at page number 349, that is what the PWD has done, my lord. Just a matter 3 pages before, my lord. And this is the reply of my lord, which I have referred at page 349. The PWD Roads has written to the chief engineer of PWD National Highways, and it has been clearly reflected that name of the contractor is Purbanchal Buildtech, and notice to proceed to the work was issued on 6/6/2023, and LOA your lordship will find. This is important because our tender last date was 11/4, and your lordship will find in that page 349, the LOA of the first work was issued on 10/3/2023. This was also not disclosed by them, other than the 3 works, my lord. The writ petitioner says that 3 work has not been disclosed. But later on, it has found that because those 3 works in the name of the only Matlabuddin Ahmed, that's why they were not disclosed. But in case of Purbanchal also, my lord, this work was entrusted to Purbanchal. Even Purbanchal had a LOA issued on 10/3/2023, which is available at page number 348. This has also not been disclosed at my lord by the respondent number 1. Your lordship will find that letter of acceptance in the just the page before at 348, my lord. This is the letter of acceptance, which was also not disclosed in addition to that ground. Now your lordship will kindly see the explanation of the PWD at page number 335. You have got, lordship, got page number 335. In page number 335 at second paragraph, the PWD has specifically stated that further confirmation regarding the concealment of ongoing commitment as mentioned above had been received from the CE PWD Roads, Assam, Sanmari, Guwahati 3, via his letter number dated 24/7/2023. Accordingly, after receipt of the confirmation regarding liabilities of the contractor, it was confirmed that the company concealed their ongoing commitments and misrepresented to the authority, and therefore the company Purbanchal Buildtech Limited stands technically non-responsive as per stipulation of para 2.6.2 of the RFP. Now your lordship will see in that affidavit at paragraph 6 also, this paragraph is the last paragraph I will refer to what the affidavit is concerned, my lord. That with regard to statement made in paragraph number 13 of the writ petition, the deponent denies that the technical bid of the respondent number 5 is liable to be held as non-responsive in terms of clause 2.6.2, and that the authorities have illegally and with malafide considered the same to be responsive. In this regard, the deponent respondent state that after receipt of objection as regard the technical bid of the respondent number 5, clarification had been sought, and after receipt of the same, the authorities have considered the technical bid of the respondent number 5. They have also raised an objection in regard to my bid. I'll show your lordship those documents, how my objections have been dealt with. But before that, my lord, your lordship will kindly look, who is this Matlabuddin Ahmed and who is this Purbanchal Buildtech Private Limited? Your lordship will kindly see the memorandum of association at page 255 of this company, my lord. It starts at page 254, the memorandum of association of the company. And 256 is the relevant portion, my lord. The first paragraph of page number 256. Your lordship got it, my lord. Your lordship will see all the credentials, technical, financial, experimental, managerial, and whatsoever from 1st of August 2022. Of Mohammad Matlabuddin Ahmed may be counted for the company Purbanchal Buildtech Private Limited for all the purpose of fresh bids and contract for supply and construction work, and for roads, highways, bridges, and all other types of construction works under Assam PWD Roads, Assam PWD Building, Assam PWD NSWOC, National Highway Authority of India, and all those organizations and any other similar departments. So it was categorically mentioned in the memorandum of association that not only the individual work of Mohammad Matlabuddin Ahmed will be counted from 1st of August 2022 as that of the Purbanchal Buildtech Limited. Now, in this regard, my lord, they have also submitted an affidavit which was downloaded from the website of the Tender Evaluation Committees, my lord. Your lordship will find at page 264 is the affidavit, and the relevant portion is at page number 267, 265. your lordship got the affidavit. Affidavit is at page number 264. The relevant paragraph is at page 265, paragraph number 4, my lord. That consequent upon the formation of the said company, all my credentials, who has signed it? Mohammed Matlabuddin Ahmed. All my credentials, technical, financial, experimental, managerial, and whatsoever, other so forth from this first day of August 2022 may be counted for the company Purbanchal Buildtech Private Limited for all purpose of phrase bids and contracts for supply and construction works for roads, highways, bridges, and all other types of construction works under Assam PWD roads, Assam PWD building, and so and so, and any other. So he has also said that all these works of from 1st of day August 20, this was also disclosed in the affidavit. And similarly, in page number 266 also, the same repetition is at paragraph number 3. And 268 is the certificate of the chartered accountant of his, who has also certified that all the credentials from 1st of August 2022 of Mohammed Matlabuddin Ahmed has been transferred to Purbanchal Buildtech Limited, my lord. And 269 is the response of the PWD interdepartmental correspondent, which also says that from so and so date, the work of Matlabuddin has been transferred. Now your lordship will also look, since they have pointed that my bid was also defect, and I have not disclosed, your lordship can look into those documents. This has been dealt in page number 294. Because my work was issued after the NIT was that 11 date. On 10, just they have said that all the bids were responsive, but no LOA has been issued. LOA has been issued subsequently. That your lordship will find. Single judge deal koisila. Now your lordship will look how the learned single judge has dealt with it in para number 29 at page number 423. Your lordship got the paragraph number 29 at page number 2. It was strenuously argued on behalf of the contesting respondents that since certain work which were in the name of the petitioner number 2 have been relied by the petitioner number 1 as a part of his credential, the aforesaid 3 works should also have been disclosed. The aforesaid contention, however, cannot countenance in view of the fact that the works which were relied by the petitioner number 1 in support of his credentials were officially transferred to his name, whereas the above 3 works continued to remain in the name of the petitioner number 2. At least I don't find in any of the pleadings this statement which was recorded by the learned single judge that this one work which they have shown in the credential, that format, that this has been transferred. I don't find any documents to that effect. I don't find any pleadings to this effect. This is beyond the pleadings and beyond any record, my lord. Then your lordship will kindly look at para 33. In paragraph number 33, this court has also seen from the material placed before this court that the financial bid of the petitioner number 1 is significantly less than that of the respondent number 5. And therefore, the element of public interest is also involved, and this aspect is also relevant, which cannot be overlooked. My lord, this is an elementary principle of a tendering process that if you don't qualify in the technical bid, your price bid has no relevance and the court cannot look into it. First, you have to be technically qualified. The Tender Evaluation Committee, the PWD, concerned authorities of the PWD has found his technical bid to be non-responsive. Then where is the question, my lord? We have not seen the price bids of the of this respondent number 1. So where is the material to come to a finding that the price that just because the financial bid is of the petitioner number 1 is significantly less, that's why his technical bid will be overlooked. But no, first you have to qualify yourself in the technical bid. Only then you can look into the financial bid, and in that case, your lordship will kindly before I take your lordship to paragraph number 34, your lordship will kindly look at page number 106. Your lordship will kindly look at page number 106. First, your lordship will look at 3.1.6.2 at page 106. 3.2, your lordship can directly look into. 3.2, opening and evaluation of financial bids. The authority shall inform the venue and time of online opening of the financial bids to the technologically responsive bidders through e-procurement portal and email. The authority shall open the online financial bids of the technically responsive bidders only on scheduled date and time in the presence of the authorized representative of the bidders who may choose to attend. The authority shall publicly announce the bid prices quoted by the technically responsive bidder. Thereafter, the authority shall prepare a record of the opening bids. Your lordship will also look into the clause 3.1.9 also in this regard. After evaluation of the technical bids, the authority will publish a list of technically responsive bidders whose financial bids shall be open. The authority shall notify other bids that they have not been technically responsive. The authority will not entertain any query or clarification from the applicants who fail to qualify. Then this exercise was never done. Then your lordship will see the concluding paragraph of the impugned order, judgment and order at page 425. The consequential order at page 34, paragraph number 34. In view of the aforesaid finding arrived at by this court, the writ petition stands allowed and the impugned decision-making process of the bid evaluation committee leading to the rejection of the bid number 1 dated so-and-so is set aside. Consequently, the financial bid of the petitioner number 1 is required to be considered and the walk-in question be allotted to the L1 bidder in accordance with law. This is what we are challenging, my lord. My lord, the learned single judge, with utmost respect, there was no document or any pleading on the PWD authorities that just because his one work which has been shown in that format, it was disclosed. That's why that can be done. So for the other work concerned, it is not in the, it has not been transferred, just like the National Highway indicating the work. So therefore, it cannot be considered. My lord, we brought to the attention of the learned single judge a number of citations of the Honorable Supreme Court that how the court has to deal in such situation. My lord, we have given the citation and the name of the parties, and we have also given the relevant paragraph, my lord. And all these citations have been discussed in page number 418 of the impugned judgment. So just to conclude, my lord, the work which will not be beneficial to him, the 3 works, have not been shown. The work which increases his credentials have been shown in the format. The learned single judge has observed that paragraph. I have already addressed to my lord to those paragraphs. If this is not material misrepresentation, then what is material representation over the work in concern? And my respectful submission is that, my lord, the tender evaluation committee is the best judge to decide among us who is the best. If there is anything, my lord, which goes beyond the pleadings, your lordship will kindly interfere with it. That's my humble submission, before lord. Subject to what my learned friend replies, but today I'll pray that so far this impugned judgment and order is concerned, it will kindly be stayed unless your lordship examines this entire matter.
Lord, I thought my learned friend will take 10 minutes. He took more than 30 minutes. That means he has a very weak case. For most than half an hour.
Because it's a development of that work. It has to be officially transferred.
Managing director.
He may be a board of
But it's-
management was to. With one person, if he can say something, so unless they can say something, it was also transferred.
Made preserve. My lord will kindly mark 2-3 dates, my lord, because the question which has been posed that itself is seeking an answer. Because the other works were done by an entity called Mehtabuddin Ahmed. And the bidder is Purvanchal. PW itself does not know, my lord, to whom the information is to be taken from. Anyway, my lord will kindly take note. 2/6/22 is the date when Purvanchal was incorporated. Now, my lord, respondent number 2, Mr. Mehtabuddin. Matlebuddin, my lord, I'll refer to as petitioner respondent number 2. Respondent number 2, before becoming a director in Purvanchal, he in his individual name, he had executed several works under different wings of PWD, including National Highway and border roads. Now, some works were done by him in the border roads. But what the PWD National Highway did, my lord, after incorporation, all my past works, liabilities, everything was added in the name of the company. Since works under the border roads were not, incorporated, my lord, therefore these were not informed. It can be a case of, my lord, separation of material fact. The basic issue is whether the petitioner conforms to the bid capacity requirement. My lord, why my learned friend has referred to page 126 and 127. That is for the purpose of assessing, my lord, bid capacity. That's why I'm saying, my lord, the case is misconceived. The department has never tried to find out that respondent number 2 and respondent number 2 are two different entities. Respondent number 1 is a juristic person and respondent number 2 is an individual. Yes, in view of the judgment of the Honorable Supreme Court in New Horizon and onwards, where is the difficulty in carrying with me my experience which I earned as an individual when I joined a company? Now, my lord will kindly, it's a very basic issue, my lord. Please come to the bid evaluation committee report, my lord, which is under challenge. Page number 172. Please come to 172, my lord. Based on representation received regarding concealment of existing commitment by bidder named Purvanchal Buildtech Private Limited, necessary clarifications were requested from the relevant heads of directorate. Specifically, Chief Engineer PWD Border Roads to letter dated 25/5/23. In response, Chief Engineer PWD Border Roads through letter dated 26/5/23 has confirmed that the bidder did not disclose the mentioned commitment in their bid. This deliberate misrepresentation of fact renders the bidder liable to be disqualified as per clause 2.6.2 of the RFP
and their bid security shall be appropriated accordingly as specified in the clause. Now, my lord, kindly see the heading. Based on representation received regarding concealment of existing committed by the bidder, namely Purvanchal. Now, which is that, my lord, work which Purvanchal has suppressed, my lord? Kindly see, my lord, they have not gone to the meat of the matter. Purvanchal has not, suppressed any fact. If at all any suppression has been done, if it is construed to be suppression, then it is respondent number 2. What is the question? Kindly see. Commitments by bidder name. Well, there is no bidder by name. Bidder by name, sorry, Purvanchal is there. But by the name of respondent number 2, there is no bidder. So they are proceeding on what? They are proceeding in thin air. Now, my lord, assuming this is correct, whether it will materially affect my technical bit. That's the issue. I'll satisfy your lordships in 2 minutes, my lord. My lord will kindly come to page number 3. No, before that, my lord will kindly come to page 246. No, sorry. 240. Better lordship comes to page number. Yes, please come to 246. The bidder named Muhammad Motlebuddin Ahmed, now known as Purvanchal. What is this, my lord? Anyway, whatever it is, my lord. Now, in column number balance value of the work, if your lordship kindly sees 5.67, 3.63, 6.27. If we add up, my lord, it becomes 15.57 crore. That means, as on the date of submitting bid, assuming it was a work of Purvanchal, my lord, they had an existing commitment of 15 crore. Am I clear, my lord? Now kindly come to page 382. My lord will kindly come to the qualifying criteria, second column, my lord, on top, at page 382. Total bid capacity required in crores, 19.29 crores. Has your lordship got it, my lord? This is the department's estimate. Please come to the last column. Purvanchal Buildtech Private Limited, 6 Mile. 55.65 crore is my lord, bid capacity. Even if we take that 15 into account, still, my lord, there are 19 and 15 breaks 34. 21 crore is still there. Now, my lord will kindly come to the impugned judgment at page number 424. My lord, why are you beating about the bush? Come to the point. Line about 6 from top. It ultimately transpires, has your lordship got it, my lord, at page 424. It ultimately transpires that though the rejection of bid on technical ground is by invoking clause 2.6.2, which is in connection with material representation, it appears that subsequently in the affidavit, the aspect of bid capacity has also been tried to be brought in which is under clause 2.2.1. In this connection, it has already been brought on record that while the required bid capacity of work is in question is 19.29 crore, bid capacity of the petitioner number 1 is 55.6 crore, 65 crore. And even if the aforesaid word is taken into consideration, it would not affect the required bid capacity. So what remains, my lord? I still have, my learned friend is relying heavily on the chart, on that format. That is what? That is for assessing bid capacity. Now, my lord, I'll just show one judgment, 79 condition. In other words, my lord, when they referred to this misrepresentation, it was uncalled for. It was unwarranted. Honorable Supreme Court in Venkataraman's case has said, my lord, if relevant considerations are not taken note of, then the decision is arbitrary. Now, learned single judge has enforced my fundamental right. My lord, nowhere Supreme Court has said that if Article 14 is violated in a contractual matter, 226 court cannot interfere. Let us not take help of those judgments, my lord. No judgment, even my lord, even in Tata Cellular, the only exception made out is violation of Article 14. My lord will kindly come to page number 491, my lord. They took note of a plea of misrepresentation. It was uncalled for. They should have taken note of whether I have got the required bid capacity or not. That's very relevant. Supposing, my lord, I have 10 existing work, then I will not be able to put in my men and effort and finances. That is why, my lord, bid capacity is of utmost importance. The requirement is 19. Those I have not given is 15. And I have 55. Still, I am left with, I have 21 crore. Please come to this paragraph 6, my lord. It is, however, not necessary to examine the question of malice in law in this case, for it is straight law. If a discretionary power has been exercised for an unauthorized purpose, it is generally immaterial whether its repository was acting in good faith or in bad faith. That means, my lord, if the power, even if the power was exercised bona fide, if it is for unauthorized purpose, then it will be bad. Then please come to para 8 and 9. We are in agreement with this view. It is equally true that there will be an error of fact when a public body is prompted by mistaken belief in existence of a non-existing fact or circumstance. It is so clearly unreasonable that what is done under such a mistaken belief might almost be said to have been done in bad faith. And in actual experience, and as things go, these may well be said to run into one another. The influence of extraneous matters will be undoubted where authority making order has admitted their influence. It will be therefore be a gross abuse of legal power to punish a person or destroy her services carried in a manner not warranted by law by putting a rule which makes a useful provision for premature retirement of a government servant only in public interest to a purpose wholly unwarranted by it, and to arrive at a quite contradictory result. An administrative order which is based on reason for which do not exist must therefore be held to be infected with an abuse of power. My lord, where is the question of, my lord, I mean, suppression of material fact? The bidder is Purvanchal. Purvanchal has not suppressed any information. Yes.
It's a material misrepresentation.
Material.
Material misrepresentation.
Yes. That is their case, my lord. Now, question is, end of the day, you are testing what? You are testing the bid capacity. Now, how it has materially affected? It has not affected, my lord, because my bid capacity is, and my lord, those works are never transferred. Works of National Highway were transferred. That's why I have disclosed. Now, end of the day, my lord, what you are assessing? You are assessing my capacity to undertake the work, which is the mechanism, my lord, under the scheme of this tender to be applied. Bid capacity. Now, please come to, my lord, this clause. Please come to page 86. Bid capacity. Bidders who inter alia meet the requirement qualification criteria will be qualified only if their available bid capacity is more than the total BID value. The available bid capacity will be calculated as per the following based on information mentioned in annexure so and so. So, there is a particular formula. By applying this formula, the bid capacity is assessed. The underlying purpose was to ascertain the bid capacity, and they themselves has worked it out, my lord. The bid capacity required is 19.20 crore, and I have a bid capacity of 55.65 crore. Assuming, my lord, those were not disclosed, those were included, then also it is, my lord, 65 crore, more, but 21 crore still left. And my lord, this 10-3-23 aspect, my lord, that is never the ground of rejection. So public order publicly made has to be construed in the context in which made. The learned single judge has referred to those. And my lord, kindly see, look at the difference in price. My bid is of 14 odd crore and his bid is 20 crore. If work is given to be, state will say 7 crore. Single judge. My lord, in my respectful submission, it's an intra-court appeal. Lordships will interfere only in a matter where, my lord, a serious error has crept in. Now, a particular view has been taken by the learned single judge in the facts of the case. Is the view so atrocious, is the view so wrong, my lord, that it calls for your lordship's interfere? So where is the question of material misrepresentation or representation, my lord? A work, I'm not Motlebuddin is not the bidder. Bidder is Purvanchal. And lordship knows that the New Horizons case, where the Honorable Supreme Court has said, as far as credential is concerned, it is absolutely permissible. 478, my lord. 1995. (1995) 1 SCC 478. If your lordships will kindly come to para 23, my lord. Even if it be assumed that the requirement regarding experience as set out in the advertisement dated so and so. Your lordships got it? Yeah. Even if it be assumed that the requirement regarding experience as set out in the advertisement dated 22/4/93, inviting tenders is a condition about eligibility for consideration of tender, though we find no basis for the same, the said requirement regarding experience cannot be construed to mean that said experience should be of the tenderer in his name only. It is possible to visualize a situation where a person having past experience has entered into partnership and tender has been submitted in the name of the partnership firm, which may not have any past experience of in its own name. That does not mean that the earlier experience of one of the partners of the firm cannot be taken into consideration. Similarly, a company incorporated under the Companies Act having past experience may undergo reorganization as a result of merger or amalgamation with any other company which may have or have no such past experience, and the tender is submitted in the name of the reorganized company. It could not be purport of the requirement about experience that experience of the company which has merged into the reorganized company cannot be taken into consideration because the tender has not been submitted in its name and has been submitted in the name of the reorganized company which does not have any experience in its name. So it is permissible, my lord. When I rather used the experience of petitioner number 2 in support of my experience, this is absolutely permissible. And assuming, my lord, I was required to disclose that also, how does it materially affect the decision-making process? That is why learned single judge is absolutely correct, my lord, in coming to the conclusion, and on top of that, my lord, please come to my lord page. Para 20. Please come to para 394, my lord. Reply. Page 394, my lord. Para 20. That with regard to the statement made in para 15 of the affidavit in opposition, petitioner begs to state the respondent number 5 had quoted a bid amounting to That's my learned friend's client, which is 4.78 per the 20 crore and odd. Whereas petitioner had quoted his bid amounting bid quoted by one is 14 crore. So there is a difference of, my lord, more than 6 crore. So that is why learned single judge was of the view that where public interest should also be served. Had it been a case, my lord, assuming there is a requirement of disclosure and disclosure was not made, and eventually it also affects the bid capacity, then it's a different issue. The learned single judge, my lord, did not thought it proper to interfere with the matter, in my humble submission, because the learned single judge found that no, even if it is taken note of, then it is still, he has got the bid capacity. So therefore, to say that the view taken is unreasonable is not correct. It's a very reasonable view. Lordships in exercise of intra-court appeal will not, interfere with the matter merely because another view is possible. The view taken is absolutely reasonable. And more importantly, my lord, when they filed a complaint, the complaint was never given to me. No clarification was sought. But when we filed a complaint, clarification was sought from him. My lord, there are few things we cannot sell. My lord. One superintending engineer who is instrumental in doing all these things. One superintending engineer is helping this, his client. My lord. That's why all these things are going on. My lord. And it's an open and shut case, my lord. What is there in it? Yes. If your lordship finds that it's a case, what may admission lordship may admit it, but in my humble submission, it's not a case of, my lord, a stay out. Let the work proceed subject to the outcome of the writ appeal. I don't think any case for interim relief is made out. And moreover, my lord, Honorable Supreme Court in NG projects case and all that said, my lord, that normally lordship will not stay infrastructure projects. And my lord, that is not, that I'm not very rigid about it. It's not that today I'm appearing on this side, tomorrow I'll be appearing on this side to say that no stay order does not matter. Having regard to the facts of the case, perhaps, my lord, the learned single judge view is the correct view, my lord. It does not call for any interference. Of course, if lordship would like to have a full-scale hearing, that's a different issue. Lordship may issue a notice at this stage. My prayer is, my lord, lordship will certainly not pass any interim order because no case has been made out for interference. That's my humble submission.
No need of issuing notice on admission. What is it? You can dispose it, or you want to get it at about hearing?
So if you feel that it can be disposed of, then no issue. You in fact are very clear. But yes. So material requirements. Not only simple. And these three works have not been transferred to the new company. It's according to me, say allotment to, how the work.
Or the work to the.
Even if this director and company by agreement, if they say also, and then transferred by the authority, competent authority.
Petition completed. But before your lordship hears, I'll give a short reply to my learned senior's submission, my lord. I'll not reply on his your lordship, if your lordship doesn't state, my lord, then my whole effort will become infructuous. So unless your lordship hears the entire matter and grant a stay, because this initially when they came before this honorable court on 5th of July 2023, it is not me who got a stay. It was there. That's why now they are not saying that infra will not be applicable, because the division bench has made it clear that in an infrastructure project, if there is something which escalation and all is there, then you have to bear it. Now today they have the advantage of the learned single judge order. That's why they are saying that we are not facing the infracom or order of the Supreme Court. So my case is that if your lordship doesn't stay the order of the learned single judge, my whole effort will become infructuous.
We'll have it heard on the early date.
Yes, yes.
But till then, my lord, there has to be status quo.
Will it be by?
No, if
10 days, yes.
no, we can hear it any day, but your lordship will make it clear that this walk will not be start, because if other rights are created, then my lord, it will become difficult, my lord. Your lordship will give a short date, but till then the impugned judgment may kindly be state, my lord.
My lord can have it on, my lord, anything from week commencing from 19th, my lord, any day. Or maybe little earlier also, my lord.
Because if your lordship doesn't grant a stay, my whole effort will become
Subject
till 19. Because this is not a case where it can be said that it will be subject to the outcome of the case.
Mr. PT Convert, assisted by Mr.
H. Agarwal.
For the. Mr. King Chowdhury and RM the.
Decca,
Huh?
RM Decca.
Oh, RM Decca. Respondents 1 and 2.
Yes, ma'am.
1 and
One and
Mr. D not. How about 7?
And at this stage, no notice be sent to him.
Oh, this is the okay.
Hmm.
Okay. It's the matter for hearing on. Keep a date.
Could it be on 19, 20, any day?
Look, since if your lordships grants a stay, then I have no objection till 19. But if he is say that he will not, he will be not, no stay will be granted.
Have it on 12th, my lord.
Yes.
Yes.
12.
Huh?
The work in question shall out.
Huh?
Deep level.
Well, the only thing is that the division bench, earlier division bench order, I will.
That is a subject to outcome of the case.
No, my lord, my friend will not dictate me what order I should submit.
No,
He
I'm
may,
saying-
no, you have passed euphemistic comments against the council. My style of submission is not that. You will say that you
Don't
can.
take it otherwise, Baba.
no,
I
you-
said I have
No,
followed.
you
Because
attack
you're
no.
talking to him, that's
No,
why I
no,
said.
no, but you have, in your submission, you sometimes pass personal comments against the council who is appearing on the other side. With utmost respect, you will try to disturb the other council by taking instruction from your juniors loudly. We are not used to this practice, my lord. We are not used to this practice. We have come here, we are, whatever order your lordship passes, it's like a water droplet in a lotus leaf for us. When Mr. Chaudhary was submitting, I was maintaining absolutely silence and trying to take note of each of his points. We don't take instruction from our juniors in the courtroom and try to disturb the other council's reading. That is not our style of practice, my lord.
Deeply obliged. We are obliged, my lord.
Item 2 to 6.
Yeah, please, your lordship.
We have to hear this street appeal.
Yes,
We have
ma'am.
to hear this street appeal.
We have filed our affidavit matters right for hearing. Also, my people date and final.
Okay.
This
Will you have it in the admission stage?
Yes.
Yes, sir, it is not admitted yet.
Would you like to argue against the admission or would you like to?
Against the admission.
You want the matter to be admitted or?
No. It has to be disposed of, my lord.
Mr. SP Laskar,
Yes, ma'am.
learned counsel for the petition, for the applicant. Also heard Mr. R. Majumdar, learned standing counsel, elementary education. For respondent,
I appear for the Department of School
Education, elementary.
Elementary.
I think
1, 2, 7. You are appearing for progress?
I'm for the writ petitioner, my lord, in WPC number 6527 and respondent in respect of WPC number 5770.
For the respondent, huh? And also Mr. P. Pulgarastal and counsel for the petitioner in WBC number
652722.
6527 oblique. List on, when do you want?
Early date, my lord.
22nd?
Obliged. Highly obliged. Hello.
Item 23 for hearing.
Yeah, I think over 15 minutes.
Item 15.
I think 15 minutes.
15 is adjourned.
No, we have not informed.
Yeah, please, Lordship.
Continuing minute.
Lordship, may kindly adjourn the matter for today, Lordship.
I think 15 minutes. We have for the fees authority minute. We have not been informed by the. Stay out of fighting minute. Whenever they cases comes, my lord, they took time without informing us, man.
Who adjourned the matter? Mr. R. Chakravarti, respondent number 1.
Whenever they case comes,
He said he has taken your
no, my
call.
lord. But next
We
week,
are
my
sitting here.
Yeah, for the
Respondent number 1.
225, my lord. Stay out of fighting against us, my lord. But we could not, my lord, install the petrol pump since 2013, my lord.
okay, let's come on the date fix.
Next week, my lord.
No, I don't know what order I passed. 8 February.
8.
Yes.
Item number 23, Lordship.
Yes.
Lordship, may kindly adjourn the matter for today,
You are for?
for the petitioner, Lordship.
Okay, on request made by Miss.
R. Medhi.
General counsel for the appellants. When?
On
After 1 week?
6th February, Lordship.
Not 6. 6 is all full.
Then 27, Lordship. 27
Yeah,
February.
27 February.
Obliged.
Item 24.
27. Item 24 is adjourned.
Oh, I'm for the respondents.
No, 24 is adjourned, isn't it? It's adjourned.
Lordship, in this case, DSG is appearing. He's
No,
out
no.
of station. Next week, any date.
Item
Lordship.
24.
24, Lordship.
It's already adjourned.
Huh?
Huh?
Number 24 na.
No, 24 also was adjourned.
24, no?
No. But the since matter is pending since 2019, my lord.
Mm.
And now already the honorable court single bench passed the order in my favor, my lord. And the appeal has been filed now for almost 5 years has gone, my lord.
Is a 2021 matter.
That case has been registered later on. And it was filed, the matter was pending for a long time since 19, my lord. And the writ appeal was registered in 2021. Since there was a condonation of petition, my lord, it was pending for a long time.
Lordship, may take up is necessary on next Tuesday or Thursday.
On 8th Lordship, Thursday, Lordship.
Lordship.
Next week we have quite a number of cases fixed.
My lord, since my lord, the petitioner, my lord, he had to join, my lord. He could not join because of pending of this appeal, my lord.
Okay, on request made on behalf of Mr.
Deputy Solicitor General, Lordship. He's out of station, Lordship.
Dev Chaudhary.
Dev Chaudhary.
RKD Dev Chaudhary, Deputy Solicitor General of India. List on 20.
Lordship.
20 February.
Tuesday.
It's my lord, okay.
Yes.
Can it be my lord on 8th, my lord?
Eight, I've told you, it's all full.
My lord, matter is going on, my lord, that is.
You'll
why-
have to keep on waiting. Eight also.
As you lord.
Public,
I'm also helpless, my lord. That is why I'm praying before Lord.
No, I'm giving you a date where we can take up the matter.
Item 26.
My lord, in this case, it will take a longer time, my lord. So, my lord, it may come on any other date. no?
On the request made by Mr. D. Procastel and Council for the Appellant. When?
The fourth week of, my lord, February. 27th, 27th,
29th.
29th.
Go, go.
Lordship.
29th.
Lordship.
27.
এই মধুচন্দ্রা 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 বাইতে
It's the last case.
Well, another 29 February maybe.
Yeah, mister?
Yes, not.
On request made by us not
Or like,
released on 29th. Tomorrow will be a little difficult.
My lord.
We can try 7th.
Seventh.
Yeah.
Oh, deeply obliged.
Item 1, 2, and 3 for admission.
Go, go. This is a portrait matter.
Okay, already heard it, lord. Hearing was completed.
No, no, these were for submission of written arguments.
Will do, will.
Hmm?
Will do.
When will you file?
Will, by next week, we will file, lord. Will do.
Okay.
We will supply it to court master, lord.
No, no, I'll list it on request. No, no, but this is a portrait matter.
Pattern matter, it's, hearing is already concluded, lordship. Hearing
Then-
is, lordship on 20, probably 20. Lordship has made it CAB on 23, 20
Yes, yes.
June, probably June, it was CAB, lord.
No, the 22/1,
Lordship,
21/12/2023.
lordship, lord.
Where's the other side?
Other side is action, lord. Lordship, without mentioning posted another day, lordship, I will inform them also, lord.
Okay.
Otherwise, lordship, it was a CAB matter.
Released on when? 9th. I'll give you 1 week time
Lordship, lord.
for submission of written arguments.
Oblige, lord.
This is not a portrait matter. It should be spoken to be spoken to. Okay.
Oblige, lord.
Item 4 for order.
This is review petition, my lord. We sought review for the judgment filed by this court, my lord.
Last time you said there was some developments taking place or something like that?
No, my lord, we'll try to resolve the issues, but the authority did not.
Oh.
My lord, the contractor under who supplied me to the authority, he said that he wrote a letter to us and we did not reply to him.
1 minute. Sharma, come. In the first matter, item 1, 2, and 3,
Yes, your lord.
You were not present, so I've listed on 9th for submission of written arguments.
9-4, your lordship.
Yes, 9th of February.
Yes, your lord.
You should submit your written
Only
argument.
the written argument needs
Yeah,
to be submitted, your lordship. Will,
It's not a question of part heard. It is to be spoken to only.
yes, your lord.
What's the date of birth?
9-4.
Make sure you file it.
Yes, your lord.
You submit.
Yes, your lord. Deep down.
Malad, this review petition
Where
was.
is the judgment?
Page 25.
Order dated judgment is 21/11/2022.
Hmm. Which part you want reviewed?
Malad, only Malad, correction of date of birth, Malad. This date of birth was corrected by the authority prior to my retirement. It was corrected. And the correction was filed on Malad 17/2. Annexure 28, Malad. Annexure G, page 28. This was the correction made by the authority prior to my superannuation. I was superannuated on 28/2/2023.
What document is this?
This is the Malad PF statement of PF, Malad.
This we have considered on the other day. This we have already considered.
Malad, that was not with the record, Malad, at that time.
No, it was the, let us see,
Page 26, the last paragraph. This court has considered annexes into this petition.
page,
The PF, page 26.
26.
Page 26, the last paragraph. Starts with this court.
Hmm.
There has to be some error apparent on the face of the record. There's nothing. His declaration is
Malad,
63.
no,
That was
Malad.
also considered the last occasion and was dismissed. Now he again comes up on a review
No,
and says
Malad.
that it has to be 69. He's already
We
retired.
have submitted our representation for correction of the date in 2022, Malad, and that has been corrected accordingly. This says that in the affidavit, it says that the correction which was made by the oil authority, Malad, that was manipulated by us. They say, but which is not at all true. Their allegation is the authority which was corrected my date of birth, fight annexure G, page 28.
One more sentence.
Hmm?
One more sentence.
This is the, my correct date of birth, Malad. And this.
This is your PF statement.
Yes,
PF
Malad.
statement.
PF statement.
How can you have a correction in your PF statement?
The-
And we
on
have
on the basis of
we have disputed this document. It has been brought for the first time in the review application. We have disputed this. And in fact, a SOCOT has also been issued against the contractor
that's
as well as
so-
this.
that SOCOT are not issued to me, Malad. No SOCOT
Obviously,
are-
he's working under the contractor.
no.
He's not my direct employee.
Maybe I am
He's
the
not my
I
direct
am,
employee.
I
In
am
fact,
the employee of the contractors,
employer-employee
Malad.
relationship is even not there between us.
I
He
am
is working under a contractor. I am the principal employer only because of that far stretch connection. He is here, making me a party and saddling a litigation upon me. And therefore, it is also not maintainable.
Malad.
And be that as it may, this issue cannot be brought in now in a review application because he wants to change the entire judgment now, saying that this document has to be considered. Whereas this is a disputed question of fact, and there has been so-called issued against this particular person who has done all this mischief.
Now, Malad, though I am a
This is a big case
contractor
for
worker, Malad,
review.
our service has been controlled by the authority, Malad. Paragraph 6 of our reply, Malad. He was the contractor. Once Sanat Kumar, he was the contractor of the oil. Malad, he supplied us to the oil authority, and oil pay the benefits to us, pay salary, pay PPF, etc. to us. Entire control and management the workers by the oil authority, Malad.
Oil never pays. Oil will have to pay to the contractor under the contract that is entered by the with the contractor. These are all facts that he's beating about the bush.
No, Malad.
These are not the pertinent issue here. Pertinent issue is that in his declaration form, that your lordship will find in our affidavit in reply, affidavit, page 46, in his own declaration, by his own handwriting, which is still not dispute, he has written as 63. Thereafter, later on, at the fag end of his career, he comes up with this plea for his honorable court saying, no, it has to be 69. I produced this document before lordships on the when the repetition was heard, and lordship has considered that, and according to the petition was dismissed. Now he brings in this document, a disputed document, in review, and he says that this document has to be considered, superseding all other documents that is already in record. So therefore, which document is to be considered or to be believed now?
See, page 26, the second last paragraph.
Of my review petition.
No, of the judgment. Yeah, of your review petition. This was, we have considered what Mr. Sharma says.
Yes.
Read it.
A statement was already considered. Now he gets it changed by playing a mischief against which the so cause has now been issued.
He has produced a declaration form which was considered by this court. And the declaration form was signed by you.
Yes.
But so far my declaration form is concerned, my lord, this is family.
Page 46 of the affidavit that we have filed, the declaration I have annexed. Page 46, date of birth, 1st month of March 1963.
Well, it was the statement of family, the employees family pension scheme 71. This was the declaration, my lord. That declaration correct, the date of birth was corrected and erased it was. I do not know who erased it, but my lord, on being seen, and as per my request, my lord, the authority issued.
I don't see any erasing.
But this is not the original.
You have the original.
I produced it on the when the repetition was.
Anyway, do you have it now?
Is it there? No, it's not.
You produced the original. After that, we supposed to.
But it was already considered by your lordship. And based on that, only the judgment was passed. That cannot be
On the
disputed
basis
now.
of my lord, what gate pass was issued to me, well, that was on 69, my lord. 1369 gate pass, ID card, as well as all the documents other than these documents, my lord.
This is your signature, isn't it?
He is not denying this. He is not denying the document. He says it was later corrected. That is what his claim is. But he cannot produce that corrected document.
Moment when I came to notice of this, my lord, we have filed representation to the authority. And thereafter, the authority issued to me the gate pass and everything, my lord. I card, gate pass, everything, where my date of birth was written as 1369, my lord. In the writ petition, my lord. In my PAN card, in my gate pass, Aadhaar card, everything is, my lord. Page 14 is the gate pass issued by the authority, my lord. In that case also, it was issued in 2011, my lord, where my date of birth was 1/3/1969.
Page 25, that we have also considered. Where is the error apparent on the face of the court?
My lord, my humble submission before lordship is.
Review petition is limited.
Yes, that is I know, my lord.
He wants to
Review
change the entire
petition
judgment.
is very limited, review scope is very limited, my lord.
So where is the error apparent on the face of the court?
My humble submission before lordship is, my lord, while my date of birth was 1/3/69, and I filed an application to the authority for correction of my date of birth. Accordingly, the authority corrected my date of birth prior to my retirement, my lord. That aspect should be considered because the document by which my date of birth was corrected, that was received after my superannuation. That is the, my lord, mistake for us, my lord. This document, my lord, to annexure
Where
G
is that,
page
where is
28.
that order whereby Oil India has consciously corrected his date of birth? If that be so, then there would have been no dispute now. He would have been very well working.
I do not know, my
That
lord.
therefore indicates that there has been no conscious decision passed by the competent authority under Oil India Limited, changing or correcting his date of birth. That is why this litigation is still continuing.
This, my lord, page 21 document was subsequently, my lord, corrected by the authority. Again, they come to 1/3/1963, my lord.
There are judgments.
My humble submission is, my lord, that is true, my lord. I know. But, my lord, my humble submission is, my lord, this document was corrected by the authority prior to my retirement.
Which document?
28, my lord, page 28, my review petition, my lord. This was the,
This I've already considered.
my lord, that document was not with the, my lord, writ petition, my lord. This document was not with the writ petition, my lord. That is why, my lord, my writ petition was dismissed, my lord. And I got it, my lord, after my retirement.
28th February we retired.
I retired from my work, my lord, 28 to 2023. And it was received after 23. That is my mistake, my lord.
Interestingly, this document is not even having a signature. Therefore, we dispute this document.
That is a computer generated document, my lord.
These are similar before that.
And
Computer generated document also should have this.
Page number 18 is
But we are disputing this document. There's already a so-called
my lord,
dispute
they have,
against the
no,
contract.
no, my lord, they have also filed a,
And
without,
this document came after the judgments of this honorable court has come.
See, you have to satisfy this court
my lord.
that there's a discovery of some facts, some documents which despite your best efforts, you could not produce it within time of hearing.
My lord,
Or there is an error apparent on the face of records.
that is true, my lord.
Now, you have to satisfy this court, otherwise I have no other option but to dismiss it.
My lord, my humble submission and my entire review petition is based on, my lord, Annexure G, page 28.
That I've seen.
This was, my lord, that was not bear any signature. That was not bear any signature. It is, my lord, computer generated document.
Get the original document then.
My lord, it was a computer generated. This is the original, my lord. It can be taken up, print out only, my lord. And they have also filed in their reply, my lord, page 50, the same document they have filed. Here, my lord, they have written as my date of birth is 1/3/1963.
Page number.
There is also no signature, my lord.
We have produced the actual at page 50.
Yes, I am referring page 50, my lord.
Lordship will see the date there. In my affidavit, I have brought the actual and therefore I have disputed this document. Page 50, Lordship will see date of birth, 1 March 1963. And before that, at page 49 is the so-cause
Both the document, my lord, bear
against
no
Sonapur
signature.
Morali, the petitioner, review petitioner, because of this mischief that they have played by interpolating that particular date as 69 instead of 63, which has been always 63 in all the PF statements, barring the document that he is producing now in his review petition at page 28. In all other documents, all other statements, it has been 63. Just to somehow make a case, he brings in a document now where it has been shown as 69. Therefore, I have placed this document at page 50 to indicate it has been always 63. And has been a mischief been played, and therefore a so-cause has been issued against him at page 49.
My humble submission
this is-
before lordship, he is deliberately submitting before lordship that this is the mischief document. Well, the inquiry can be directed whether it was mischief by the petitioner or by someone else. If it is mischief by committed someone else, he should be
Review
punished.
application, I think, will be 2 parts better. These are all
Then
documents subsequent.
why he is submitting mischief, my lord? The page 28 document and page 50 document is similar, my lord, bearing no signatures.
Have you replied to this show cause?
Yes, my lord, we have replied.
What is the
We have
outcome of
we submitted our reply.
I have no instructions regarding that reply. No. Whether he has replied or not, I have no instructions as far as today's concerned. But he has not annexed that reply with his record. Even if he has filed some reply.
Have you replied?
Yes, my lord.
But all along the PF statement have shown his date of birth as
Page
63.
55, my lord.
Only this document wherein 69 has now come. Based on which he
Page
filed
55 of my reply affidavit, my lord. 55.
55 is
Annexure L.
Annexure L, my lord. This is our objection, my lord. Herein, my lord.
no, do the show cause notice.
Why not? So called is not, we have not received any so called till now, my lord.
Then why are you saying you have replied?
No, reply, my lord, the page number 50, which they have annexed, on that PF statement we have objected.
The so-cause is very much a part of this proceeding. It is in his knowledge.
No, no, my so called was
Data
not,
statement it has
so called was not
received.
supplied to us, my lord.
Surprising.
No so called, no notice was served upon me, my lord.
Direction
Earlier, my lord, this court was, my lord, it was, my lord, court.
We filed this affidavit on August 2023. We are in February now.
This so called was, my lord, my instruction, my client has not received any so called as on today, my lord. Earlier, this matter was raised before this court, my lord. The court was viewed that the inquiry should be conducted and they should be produced the record where, how they can submit, my lord, serve the notice. But they did not do so. They show me that this is the so-called notice I have received. We have replied only, my lord.
What about page 49?
That is the so-called. It is very much a part of the record. Copy has been served to him. He has the knowledge of this
This
so-called.
49 was, my lord, not received by us, my lord. As on today, my lord. This was issued on 28 to
See,
2000,
Oil India Limited
my lord.
issued a show cause notice through the proprietor. Correct?
Yes, yes,
Through your
Contract.
yes,
Contractor.
contractor.
Your contractor on 28 to 2023, after you received this,
No, no, that was not received by my lord.
wrote to you.
No, my lord. This 28 letter was not received by me. Oil India Limited Authority write a letter to the Sunaf, my lord, to the contractors. And contractor write a letter to me which was not received by me, my lord. I have come to know only page 49, my lord, annexer from 28 to 23 letters, my lord. Still, I have not received any notice.
This is the
That is
so-called
why, my
notice.
lord, no, that is so-called notice, my lord. But we have not replied as of today, my lord. But they did not file any, they did not serve any notice to us as on today, my lord. Earlier, this court is viewed that they are directed to produce the records whether I have received this notice or not, my lord.
Whatever this, give me the two questions that I'm asking you, that you have discovered some documents despite your diligence, you could not produce it at the time of hearing of the writ petition.
Nothing is there.
Number two, error apparent on the face of records. This two, you satisfy this court, I can consider the review. If you can't satisfy, I have to dismiss it.
My lord, my humble submission, my lord. The Annexer G, the entire review petition is based on Annexer G, my lord. Annexer G, that was the PF statement which was issued by the oil authority and that was received by me after my retirement. That is why this document could not produce before the writ court, my lord. So only
They have produced another document indicating that your date of birth is 1963 on the PF statement itself.
yes, my lord. Yes. That is why, my lord, we have
All this while in the PF statement, your date of birth is 1963.
Exactly.
yes.
Suddenly after your retirement,
There is one thing.
you bring in one document saying that it is 1969. Correct, 69 or 68?
69.
How do
My-
you explain this?
My lord, in our earlier petition, my lord, moment when my PF state
And this PF statement of February is not a discovery of documents. Is a event which took after the judgment was pronounced.
Exactly.
that is to my lord.
Yeah,
The moment
not a
when we
discovery
came,
of
no,
documents.
when we came to know that my PF statement, in my PF statement, my date of birth was recorded as 1/3/1963. And thereafter, my lord, we have filed representation before the authority to correct this PF statement. And accordingly, my lord, the oil authority corrected my statement by 17 to 23, my lord. And
After your retirement.
no, that was before retirement. I
No,
retired.
you retired in January, isn't it?
No. I retired on 28 to 23, my lord. Prior to my retirement, it was corrected, but this document was received by me after my retirement. That is why, my lord, I could not furnish before this court, my lord.
When did you retire?
20th February.
20th February.
20th February. But this is a document that I'm disputing. I'm saying
That is, my
this
lord.
is a false document. Because that is why I have produced this document at page 50.
So this is a disputed question of facts.
Yes, I have produced 63.
This court
June.
can't go into that.
Exactly. This will require proof of document under the Evidence Act.
You'll have to go before the civil court.
He has to first get a declaration that this document is a genuine document. Then maybe he will have some case.
My lord, let them be produced the records who my lord issued this document from the oil. Is the oil,
Do you have, is it issued?
if it is my lord,
My inspection is that this is a document which is the manipulated document of February. So therefore, I have produced a document of June 23, wherein the date is 63 again. And the previous PF, which a lot of considered earlier, was also 63. So there is only
That
one
was
singular
considered.
document. In his entire service career, he can produce one singular document of 69.
This PF documents, do you generate monthly?
Monthly, yes, Lord.
Then let us see about January. Generated monthly or let us see the last month before he retired of January 2023. June. Because this is of June, the one which you are relying on. is
Yes,
June.
Lord.
If you have, you can produce.
I can obviously produce the previous ones as well as the subsequent ones, whatever is there. But my categorical submission for
No,
losses,
that I've got it.
it was always 63,
That I've got it.
barring this document that is now
So
produced.
January one, I want to see, so that if it is
I understand.
63, this is a different matter.
I understand.
ID proof to be issued by the authority.
Any PF statement prior to 17 February 2023, the document that he is now producing,
It
of
will
the
be-
near proximity.
It will be better if you get January one,
Yes, if it is monthly, that instruction I don't.
unless,
yes,
unless it is not done monthly.
yes, that I don't know,
Oh.
monthly or quarterly.
That you can take instructions.
I will do that, and
And
accordingly,
it-
I'll produce the document.
The latest one.
I'll do that. Just prior to this, whatever the latest one is there.
well, in latest one, my lord, it will definitely, it will 1,363 will come. Definitely,
Then there's no point.
there's no point, my lord.
That's what I'm
That's
saying.
my submission
Then
before
the
lordship.
February one, we can't take into consideration because that is in dispute.
Yes.
Well, that is why inquiry should be, my lord.
What type of inquiry?
Well, the official inquiry can be directed, my lord, by a person who independent person, my lord.
You'll have to go before the civil court to
Civil court, yeah.
authenticate your documents.
Correct.
Because, my lord,
You can call in for witness the persons that probably has done this, according to him. But not in a report and that too in a review petition.
My income stop.
my lord.
And
If
there are
it is, my
judgments of
lord,
this Honorable High Court and the
Okay.
Supreme Court at the fag end, the
Otherwise,
court wanted to change the date of birth.
dispose of this review.
it is up to your lordship, my lord. But my humble submission, who issued the February PF statement, my lord?
You produce it, you should know.
I'm the layman, I don't know.
I am, in that time, my lord, I cannot, because the
You are the one who's producing it.
Yes.
I produced, my lord,
So
because
he has
office
to-
supplied me to, me after my retirement, because retirement benefit should be, my
Who
lord,
supplied you? Who supplied you?
office, my lord.
Which office?
Here, my lord, contractor
These are
supplied,
all disputed questions of fact.
contractor supplied, because this amount is entitled. Service benefit, I
And
should, my
the
lord.
contractor is not a party here. That is another interesting aspect. Contractor was never a party in this entire proceeding.
After retirement, my lord, I have to receive certain service benefits, my lord.
He will get
That
that.
is why PF statement is required. And my lord, on the basis of my representation and everything, my PF statement has been issued prior to my retirement, my lord. This was the last PF statement which I am entitled.
I get passed through with the parking 69.
Other than this, my lord, family scheme, all the dates are 1/3/69, my lord.
Okay. You do one thing, produce all the PF statements
I'll do that.
from June onwards.
But he has already accepted that it will be 63 only.
Whatever it is, you
I'll do
produce it, I'll dispose
Yes,
it
Lord,
of
I'll do that.
on the
I'll
next.
I'll do.
Can you do it in a day or two?
By the way, Alipur. Huh? First, I can have it tomorrow then. Because it will come by PDF file only from the company. I can.
Okay.
I'll endeavor to get it by tomorrow. So Lordship, I have it on tomorrow. Lordship has already heard the matter.
There's nothing much to be heard
Exactly.
about.
Yes, Lordship.
Just produce those documents.
I'll do
after
that.
we can
I'll do that.
discuss. But Mr.
Decadence.
DK Das, the counsel for the petition. as well as Mr. A. Sharma, Limited Standing Council,
Oil India Limited.
Oil India Limited. List the matter again on. Tomorrow. Tomorrow is checking. The second.
Oblige you all.
Document দিব